75 years. His mother was serious ill, my lord. Kindly to
Where is the copy? Give the copy.
no, no, if I will give the copy.
You give the copy why don't you hold? Yes.
The Patilite is custody since last 4 years being conducted on the kindly take up for final. Because in the coordinate period you had 2-3 times, but it could not be disclosed.
What is the sentence? What is the sentence? Sentence awarded.
Books under POCSO Act.
I know, but is this 20 years? Undergone about 4 years. Take it. Yes.
Criminal can be
Not next week, we'll see. We are
after
streamlining things.
for 10th, 11th, 12th it can be
May I please, Your Lordships?
Give the memo. Give.
Pardon to mention, this is a criminal appeal of the year 2010, and the case is pending from past 16 years, and my petitioner is suffering from old age illness and is suffering from paralysis.
The offense?
The offenses are under PC Act, Prevention of Corruption Act. My lord, since 2010, the matter. Another matter is of the year 2025 and criminal revision. It is also.
Give the memo, we'll see.
May I please, Your Lordships?
Yes.
Your Lordships, I'm in VC. Your Lordships, I'm mentioning 2 criminal revision applications. Your Lordships, the matter is pending since 2022. And Your Lordships have directed that the matter should be listed on 1/3/2023, Your Lordships. And in both the matters, the trial have been stayed, Your Lordships.
I believe you mentioned it. I said you give memos.
Your Lordships, this is another matter, Your Lordships.
Okay. Where
This
is
is not
memo?
that.
May I please, Your Lordship?
Both the
May I
matters, Your
please,
Lordships, I'm giving.
Your Lordship,
I'll indicate it.
IF
I'll indicate it. Give.
My lord, weekly list item 5, since the CBI council is there, I pray to take up today, Your Lordship.
Yes, Mr. Naik.
Your Lordship, 2 o'clock one matter is specifically listed. Mr. Moond is arguing. Can it be taken up next Thursday, Your Lordships? I'll be ready.
It's Thursday because he's engaged in that matter.
Yes, sir.
Yes.
may I please, Your Lordship?
Yes. Yes.
Your Lordship, I have filed an IF for suspension of the sentence in CRLA number 1054 of 2024, and the IA number is 1263 of 2026.
Yes. Yes.
So I'm requesting this honorable court may be listed on tomorrow.
Somebody, is there anyone here on your behalf who can give a memo?
Yes, Your Lordship. But I see
Give a memo.
the honor another. Yes, Your Lordship.
Give a memo. We'll see.
Yes, Your Lordship. I'm obliged, Your Lordship.
Yes.
Criminal appeal of the year 2024. One is the father-in-law, 2 is the mother-in-law. They were thrown out on bail. Now they are in custody 2024.
Give the memo.
Yes, ma'am.
Give the memo. We are trying to streamline things.
Yes.
Almost all the matters are getting listed. Yes. Yes.
Supplementary list item 1.
Your Lordship,
Yes.
the personal direction as per the order of this one, the IAC is present in physically today and the BCB Bhubaneswar in BC. The Lordship first take up the matter sub item. They require to be modified that. Inadvertently, so
But why these people were asked to appear?
because 2 to 3 occasion the object modification could not be filed. On verification,
Why? What is the
on
problem?
verification record, I have taken the argument that the copy was served in court. So it was not, AG officer not served. So uploaded him. That was specific time.
No, just see the dates.
And
How many dates?
that 4 to 5 date was there. Letter was communicated. On LMS.
You communicated to whom?
Yes.
You
But
communicated to whom?
IIC also deceived.
He is the IIC.
Yes. Is the IIC.
Yes. What is the problem?
LMS upload in this. Personally, I am asking some to install it. After the upload, first I am told.
Upload कोठी ले? Upload.
LMS रे AG officer upload हुए. जो all the
But the copies are there. You people are appearing here and taking time. As per your convenient time is granted.
No, that way makes sense. But on verification entire record, the copy served in the court, not in the counter. जो counter is served हुए,
You create a parallel procedure. You create a parallel procedure. For that, why should court will be,
We may excuse for that because that on our side that difficulty has been caused. We should not blame to others. That's on 30th. It was on 30th.
And I have called the DCP for that. Mr. Jagmohan ji,
Sir, namaskar, sir.
you sensitized all your IICs that
Yes, sir.
whenever some instruction is sought by the government advocate, at least they should give importance to that.
Yes, sir.
This is also their part of job.
Yes, sir. Definitely, sir.
This is also part. You have to sensitize them, all of them.
Yes, sir. I will sensitize.
See, we have been getting complaints from the state councils that despite letters are being issued to the IICs and police officers, they are not giving instruction to them. As a result of which the matters are getting urgent time to time. So that's the reason. That's the reason I asked them that at least the senior officers should come.
I will ensure, sir.
You have to sensitize them.
Yes.
Issue appropriate instruction to all the SHOs, IICs under your jurisdiction that whenever there is a instruction sought by the government advocate, they should furnish immediately.
Followed, sir.
That's the reason I wanted that you should be present so
Yes.
that it can be conveyed to in the right way, you know.
Yes, sir. Understood, sir.
And IIC is here. He has no. He has given the instruction right time according to.
Yes, yes. On 30th, he personally came on 30th. We verified our record. The record shows that the AG office, we have verified the LMS upload hayni. So they could not ascertain from that. That's why we, on 30th we provided, on 31st.
Whatever the orders are being passed here,
And that has
and
completed.
again you have to upload it in the AG office.
No,
portal.
the suppose IA has been filed to provide instruction, they have to collect the document from the LMS. So they could not find anything. That's on 30th we verified, and on 31st we have filed a petition.
You have not communicated the order to them.
We have communicated.
Then why should they wait for that?
But in LMS there was no IA was uploaded. That was the misconception.
The IA copy you might have given, na?
No, LMS, no hard copies now. On LMS only.
Hard copy you have not
No,
supplied.
from house. Not purely defect. On our office, LMS through.
Let us understand what is the system. If hard copy is given by the other side, you scan it and upload it.
Upload.
Why can't you give the hard copy to the
But it is difficult. Nobody is difficult to communicate throughout the state.
when you give a letter,
Letter.
along with the letter you can send
Yes, we have mentioned that you uploaded from the LMS portal and provide the instruction. That was the standing circular also. Now what I understood that now the Hon'Ble High Court and AG office now they put common portal is created so that any
it can be
any uploaded court portal also that can be collected by the office. That inconvenience will not be caused in future.
And whatever is there in the court portal, they can access that.
That process is going on.
Okay, Mr. Jagmohan, thank you.
Sir, thank you so much, sir.
But you have to issue written instruction to all your this thing. Okay.
Yes, sir.
Okay.
Yes, sir.
Yes.
Namaskar.
Yes.
The sub item can be taken up first. The sub item, my lord, 1087/2025.
Yes, in sub item I have to issue notice.
My lord, a copy has been made. IA, my lord, a copy has been.
I'm issuing notice in the sub item. Because what had happened is,
My lord, I am taking the IA, my lord.
I have to modify that order.
Yes, my lord, I am
I
taking
can't
the IA, my lord.
perpetuate.
My lord, I will file the reply.
What
What
reply?
reply will file my friends, my lord. He is
And it
taking
should have
advantage.
been pointed out by you
Yes.
or the state council. None of you have pointed out. And unfortunately, he
Tried to take advantage
move an application seeking modification, taking advantage of your order. I can't give, that is a completely, that part has to be restored. You have to face the trial insofar as the immoral trafficking act is concerned.
Yes.
So I'll modify that order.
My lord, a copy of the IA, my lord, so that, my lord, I can take instruction on my client, my lord. Yesterday night, my lord,
No, this is an order made by me. I have, it was brought to the notice of the court. I can correct it.
as your lordship.
Why should I, since you are there, I'll correct it.
Yes.
I'll correct it.
But one thing, Lordship can correct. I have nothing to say. But if your lordship sees it needs a relook, in a modification also your lordship can relook the matter. Immoral Trafficking Act will not apply to me also.
You can't re-argue, Mr.
But how can the
you can't re-argue the matter.
modify the
But
judgment?
Lordship is recalling the order. Your lordship.
I am not recalling. I am not touching your. You. Thank you very much to that you brought brought to the notice of this court. You can't take advantage of an order which is inadvertently passed.
Yes.
Taking modification. So therefore, you only to the extent I can tell you. Thank you very much. That's all. Nothing else. No relief to you. No relief to you. Rather, because of you, the relief already inadvertently given to him will be withdrawn.
That foundation goes, then everything.
But the question is, yes, I am grateful that your lordship has expressed that. But one thing your lordship may kindly say. Even if your lordship sees that order, if your lordship passes it in my lunch senior's case, that is the right order, man. In fact, because your lordship evaluates this thing, because now it's a recall application. They have filed an application that your lordship has to decide on merits afresh, because they are seeking recall of the. If my lunch senior, I can assist my lunch senior, your lordship will find that that act also does not apply. That needs a relook. So
You have you. This point is very good, but in some other court.
But your lordship,
You generally go there. You can do that.
your lordship,
You argue that.
your lordship may hear us. Hear us. Someday your lordship may hear us. If we are,
I am hearing you. Tell me, satisfy me.
yes. My lord may kindly see section 3. It is my senior's case. He has to, in fact, lead the argument. Because I want to take advantage of that order. So if my learned senior is ready, let him lead that, how section 3, 4, 5 and 6 is not applicable. That we can just demonstrate from the act.
Now, in so far as your case is concerned, now trial must be proceeding.
No, man. Trial is not proceeding.
What
Trial
is
is
happening?
proceeding.
What is happening?
No witness are coming. Because there is no enlisted witness of those ladies.
Well, the ladies have gone to their
They have gone to
country,
Thailand.
their country.
They have gone back to that country.
Then you will be acquitted. Why do you worry?
No, no. Question is acquittal or conviction is not important.
Immoral trafficking.
My lord, I have annexed that in my application also. That act itself I have annexed.
Yes, let us see. Let us see what point of law is there.
My submission is
Yes.
first that order 1087 be decided, then after my non-appointment. He wants a judgment. The judgment has been passed. How the IA is maintainable to modification of that judgment?
You are right there. I am fully with you. But what he's trying to say, Mr. If he can, his order,
His order,
Naik's order sustains,
entire,
then he may be benefited.
that the beneficiary of the 1087 entirely depend upon the order my most client.
State council slipping when you are not supposed
No,
to.
whatever
That's a
mistake
different
has
story.
been
That's a
committed,
different
that cannot be
That's it.
attributed now.
That is the reason.
It is the duty of the officer of the also is
With that,
State council is there to protect.
that full then, your lordship never passes an order.
That's right, but sometimes it happens. See, 100 matters, sometimes it happens. It may, they may also skip, I may also skip, that happens. It is a legal issue now.
Yes.
Legal issue. It has to-
Corporate matter कोई दिया हो जो order was passed.
That's a legal
Happens.
Then your lordship asks the state council whether they.
I think, one minute. I think, Mr. Naik, since now I'm issuing notice to the petitioner, and since you are appearing, I waive notice, and you address.
I will address the issue, my lord. Today,
I'll list it, because this is a legal issue, let us.
Yes.
but happened, my lord, today I have received the copy because they have filed the modification without giving me a copy, my lord. So yesterday night, my lord, when I saw the list, my lord, I have gone through your lordship's
Second
order, my
item,
lord.
second item, issue notice to the petitioner. Mr. Naik, since Mr. Naik is already appearing, no formal notice be issued, and Mr. Naik is instrument to address the issue. In subject, list the matter of search. I'll list it and get ready with that legal issue.
Next week, man.
Two issues are there. Whether it can be corrected or on merit, you have to justify the order which was passed in your favor. Insofar as Mr. Bose is concerned, Mr. Bose has to address whether in a disposed of matter, an IA of such nature is maintainable or not. These are the two issues.
Yes.
Let us
In the past case, personal appearance may be.
Yes, yes, dispense.
Can it be next Thursday, madam?
Next Thursday.
If my senior is ready.
Any day, madam.
Next Thursday.
As your lordship.
Next Thursday. Okay. These are the two issues I have
Yes.
flagged.
Yes.
You address that issue, maintainability of the IA after the this thing.
Yes.
You have to justify your order.
I will.
If your order is justifiable and it sustains, then the question of benefit flowing to him.
But I will show you lordship, my lord, how my lord, so the engagements are not applicable to the present case.
Yes.
I'll be.
If sustains, then automatically the benefit goes to him. If it doesn't sustain, in that case,
But
what
your lordship
situation?
passed that order, my lord, your lordship, my lord, gave a really lengthy hearing, my lord. Also, my lord, your lordship heard from the council appealing for the state and also.
I don't know.
My lord, your lordship has also recorded the, my lord, statement of the Lord and Council for the state, my lord. Now they are, my lord, saying that, my lord, it's a modification of the order. We don't know anything, my lord. It's now a new chapter, my lord.
Let us see.
No, entire order marked on the basis of clients.
No,
Entire.
So
We'll
your
see.
lordship, my lord,
Whatever order reflects, I am saying.
can give us one chance, my lord, so that, my lord.
Therefore, Thursday.
Yes, my lord.
Yes.
We can argue the matter, my lord,
Yes.
so that, my lord, how, my lord, your lordship's order is just.
Yes.
I will assist my senior as well as the court on
Yes.
that, how 3 and 4 to 6 are not maintainable.
Yes. Yes. Supported with some judgment.
Well,
Yes. Yes, anybody is ready? 33. Who? Mr. Mishra, come. 33, ready. You are also ready?
11.
11. First I'll see the 11. Yes, madam.
Appellant number 2. Appellant number 2 convicted under section 307 IPC, sentenced to undergo RI for 3 years. Appellant number 1 and 3 convicted under section 323 of the.
Yes.
For the 3 months. Other appellants are acquitted. There are 5 accused persons.
Yes.
2 accused persons are already acquitted. The appellant number 2 convicted under section 307 IPC, sentenced to undergo RI for 3 years. Appellant number 1 and 3 convicted under section 323 of the IPC, sentenced of
Arjun Dalai and Dhadu.
That's it. Occurrence.
They are convicted under section 307. Okay? 3 years. 3 years. 3 years.
Keshav Dalai. Appellant number 2.
Keshav Dalai is also
307.
Weekly.
Appellant number 2.
for 323 also 3 years. Anyway, yes.
Occurrence took place 27/1/1997.
Yes.
Charge under section 341, 307, 506, 34 IPC.
Yes.
Prosecution case is that on
Five people were put, right?
accused persons are there.
Yes.
The 2 persons are already been acquitted by the Law and Trial Court. On 27/1/1997 morning, 5 accused persons are damaged the fence of the informant and they tried to encroach the portion of the land of the informant.
Yes.
The informant protested the accused persons, rebuked him, and that the brother of the informant PW1, informant brother PW2, the brother of the informant injured. The brother of the informant is the injured in the PW2 arrived at the spot and they also forbade the appellants. Appellant number 2, Keshav was armed with a cutlery and they assaulted PW2. The result of which the injury received bleeding injury on the left hand and a finger of the left hand.
The PW2 is the injured.
PW2 is the injured.
Only one injured.
Yes.
Only one injured.
Only one.
Then let's go to PW2 first.
one injury and one injury. Palm and three injury. Two injury are simple in nature, and the other injury that is the evidence of the doctor.
Yes.
If,
Yes.
other two appellants, the appellant gave a blow to informant with
Let us,
help of a lathi.
let us read the evidence.
PW1.
PW2 injured.
PW1. PW2 is the injured. I know the accused persons on day in the year of 1997 at about 8 am. I was in my house being called by the daughter of the PW1. I went to our bari. The bari is at a village, Olarpur, but it is near our house. The accused persons were putting fence in our lands. My brother was forbidding them. I also protested. Accused Kesava gave me a blow with the help a cutlery, aiming my neck. I raised my left
Accused Kesav is
the appellant number 2.
2.
The offense under section 307.
A2 gave me a blow
Gave
with
me
the help of Koturi. Okay. Aiming at my neck, I raise my
received in injury
left
on
hand,
my left
take
palm.
blow, receive injury on my left palm. My brother Ravindra was giving even blow with the help of lathi. Ravindra is examined?
Ravindra PW1, informant.
Okay, PW1. 1. ठीक है. फिर blow Arjun and Dadu.
Dhadu, appellant number 2, 1 and 3.
A1 and A3. Yes. Given blow to my brother.
Gave blow my brother. He received a swelling injury on his left leg.
Leg injury.
That's it.
Okay.
Leg injury, not injury, swelling. Only swelling. I received a bleeding injury and I went to be only the cross examination. Let's see the kindly see the paragraph 3.
Yes.
Paragraph 2 and 3.
Only one accused gave me the blow.
Here.
Only one accused gave me the blow. Important. That is A3. No, A2 gave the blow. A2. A2.
Appellant number 2. 1 and 3 swelling. Usually lathi.
Also, which is like that leg swelling.
Let's see kindly cross examination maybe.
Yes, read it. Which part? Para 3.
Para 2.
Yes.
That there was no dispute regarding the fence before the date of occurrence. I was examined by police after the occurrence. I have not stated to police that being called by the daughter of Ravindra, I went to a spot. It is not a fact that I have not stated to police that the accused persons were keeping fence encroaching our land. It is not a fact that I have not stated to police that my brother received injury on his leg and his neck, and that I received an injury on my left palm. It is not a fact that
Yes, I read it.
not stated to police.
I read it. Come to PW1.
PW1.
What PW1 says?
PW1. That's it.
Para 1.
Paragraph 1. I know
My brother Sudhir Polai is PW2.
PW2 take bath.
Came and forbid them. Accused persons trying to kill Sudhir Polai.
Sense land.
You gave a blow with the help of Katuri. And see, Sudhir Polai doesn't say that to kill. Accused person saying to kill Sudhir. Sudhir doesn't say that, saying to kill.
Yes. Sudhir is the PW.
He doesn't say that saying to kill. See, you have to give the intention part. If the intention part goes,
there is no intention.
Intention part goes, 307 goes.
307
Goes, yes. So this part is not said by Sudhir. Not said by Sudhir.
The doctor, the PW6.
Yes. Left palm and sustained bleeding injury on the finger. Arjun and Thadu gave me blow with the help of lathi. I sustained swelling injury.
Swelling injury.
Who is doctor? Who is doctor?
Doctor is a PW6. But IU has not been examined. And the
PW?
PW6.
6. What is this?
There are 3 injuries.
Hmm?
Injury number 1 and 2 are simple.
He examined whom? Sudhir.
Examined Sudhir.
PW2. PW2.
PW.
Inside room, left side front, so left hand. On the left elbow. Dislocation of the left internal injury one are simple in nature.
Left palm.
Nature, injury number 3, grievous in nature.
Injury number 2 can be caused by fall. The medical doctor. Injury number 2 is the grievous in nature. The report of the doctor. Injury number
3 is grievous in nature.
3.
1 and 2 are simple in nature.
Exhibited 2. Exhibited 2 ta hoche injury number 2. Sorry, injury number 3.
Hard surface.
Can be caused by fall. That is the
Injury number 1 might have been caused by sharp cutting with
injury
one.
number 3 is the
And injury number 2 and 3 might have been caused by hard surface.
injury number 3.
I will not examine.
I will not examine.
Then PW1 and PW2 are injured.
Then PW1 is not injured.
PW1 is also injured. And informant also. He also said that Arjun and Tudu has given me blow.
Swelling, only
Swelling, but that the doctor says PW6 he received 3 injuries.
3 injuries in the PW2.
Just see 6, madam. 6 also finds 3 injury insofar as PW1 is concerned. Second para.
Yes, ma'am.
All are simple injury.
After swelling.
All are simple injury though, but yes.
Yes, all are simple in nature injury. The
No,
P07.
One injury is grievous. Injury number 3 is grievous.
Injury number 3
Received by PW2.
Kindly cross-examination PW6 doctor.
Okay. Let us see. Injury number
3 of exhibit 2 can be caused by fall. The both party are the ଯେତେବେଳେ ସେ ବାଡ ବୁଝାବୁଝି ହେଇ ମରାମରି ହେଇଛନ୍ତି ପଡିଛନ୍ତି ସେ
Injury number 3 is not possible by fall. But it can be caused if somebody
left hand of the Sudhir Pallai, injury number 3, paragraph 3, Lordship cross-examination.
Last line.
Last line. Sudhir Kumar Pallai, injury number 3, exhibit 2, can be caused by
fall. Can be caused by fall. Then you should have stopped there. Para 4 just read. Why have you asked this question?
Exhibit 3 can be caused by fall. Injury number 2.
Injury number 3 is not possible by fall, but can be caused if hereby substance. Why have you asked this question? If you would not have asked this question, there would have been some doubt.
307 is not made out. There is no intention.
The only thing what we can say is PW1 says saying kill Sudhir Palai, he attacked.
Yes.
That there the intention is attributed. Okay? But Sudhir Palai doesn't say that.
Yes.
Yes, sir. So therefore the intention was not there and it's not the vital part. Next is attack on neck. Somehow it is escape. So there are the two things. PW1 says kill Sudhir, thereafter attack. So the intention is there. And attack on the vital part, neck. But injury is not in neck because he has shown his hand and hand injuries. So therefore, it can be a case of 307. That is the two aspect. But in first aspect is concerned, Sudhir himself doesn't say that there was a threat to kill. I have not examined.
I have not been examined. I have to know more.
What is the period undergone?
Period, there is.
Just see. What is the period under? Just see. Check it. Period undergone, you just tell me, I'm just coming. Just see period undergone. Just coming with second. Check it, huh?
Yes, sir.
The incident happened on
197.
27,
197.
what is the charge sheet?
Committed by the
Arjun and Dadu were arrested after the NBW was issued on 18/7/2003. 18/7/2003. See? Memo of arrest is there. 18. You see the proceeding and find out.
2 months, 3 days.
2 months, 3 days.
3 days. Total.
All three.
All total.
2 months, 3 days, huh?
Yes, ma'am.
2 months, 3 days. 2 months, 3 days. I'll convert it to 324. 324 because one of the injuries grievous. 324, 325. What is the weapon used?
News is Koturi.
Kotturi.
Yes, ma'am.
And PO. I'll grant PO after converting. Where 307 is there, I can't give PO. But I'll convert it to 324 and grant PO. That's best.
Arjun Dalai must have been 73 years.
73. What is the age? Say
15. Arjun Dalai
50 years.
73.
About 70 years.
73 years.
And these people are in 50s, late 50s.
So,
There you go. Yes. Yes. लिख दिए थे yes 20 33 or 23 14 अच्छा 14 कुछ yes
It was hard.
You are there?
Last occasion, my lordship, my senior said that the marriage is not valid. For that, 498 will not come into the rules. But I just want to show 2 or 3 things where it shows that the marriage is valid marriage, my lordship.
Yes.
My lordship, kindly have a glance to page number 48.
40?
48.
48.
Statement.
Yes.
Statement. That is 313, my lordship. Statement of the accused.
Yes.
Your lordship, so question number 8, my lordship.
Definitely. Yes.
Question number 8, my lordship.
Question 8, huh?
Yes.
Yes.
PW6 Gaurimon Senapati has stated that while he was working at RMC Subbanidhi check gate, as a gate in short, heard cries in your house during midnight, and on going to your house saw your wife Mani having sustained burn injuries and struggling for life, and she told that she burned herself by pouring kerosene. This witness has taken your father to Gunibuddhi Ashram for arranging a vehicle, but no vehicle could be arranged there, and ultimately injured Mani was taken in a tempo to Kisitati hospital. What do you say? Sapta. And the person is saying Sapta. That means he admitted that the money is the deceased is his wife.
No, how you?
My lordship, question number 8.
No, I read it, but told that she burned herself by pouring kerosene. This witness had taken your father from
Wife, it was written money, and he agreed that yes, Sapta.
That's a wife money.
Yes. Second, my lordship, kindly come to question number 13.
13.
Yes.
Yes.
PW10 has further stated that he seized one silver Tiberi light having kerosene, one half burnt sari, one yellow saya partly burnt from your house. What do you say? Sapta. That means the occurrence took place in her in-laws' house, my lordship. When it was proved that the occurrence had happened in the in-laws' house, so marriage is valid, my lordship. And second thing, my lordship, question number 14. Regarding the dowry, my lordship. So, PW11 Sangram Kesari Behra stated that during course of investigation, he had made an inquest over the dead body of the deceased Mani and had sent it for the PM examination. He effected the seizure of the dowry articles on production by you and had sent the exhibits for chemical examination. What do you say? Sapta. Yes, he has agreed to this, my lordship. Second, my lordship, kindly have a glance and last page. Question number 19. What more you want to say in this case? Mani Ghara Mammu Ghara Gobindpur.
Rasa Gobindpurku asitila.
My lordship, last part I'm just last page.
Mammu Vishu mu ghare. Last part what you say?
Last time ubhe parasparu ko bhallo paithilu. Means we love each other and the marriage had taken place. That part I will
No, love is there, but marriage part.
My lordship, I would take the Kitarani Sasmal, the mother-in-law statement. Next page, 52. Question number 9, my lordship.
Yes.
PW7 Umesh Dey has stated that hearing dew and cry in your house and seeing gathering, this witness came to your house and saw your daughter-in-law Mani having sustained burn injuries and said disclosed that she burned herself by pouring kerosene. What do you say, Sapta? She was admitting that she is the daughter-in-law.
Yes.
Then my lordship, kindly have a glance to page number 58. This is the father-in-law match. Question number 8. 8, 9 and 14 is relevant.
Yes.
They agreed that she is the daughter-in-law match, which proved there is a marriage. And the evidence...
Saw your daughter-in-law.
Yes. And they are not objecting this one. They are saying it's a true marriage.
Yes. We 59, just see 59. Page 59, question 19. Read it. What is written? Who? ରାତିରେ ମୁଁ
ପଚାରିଲି
ଝିଅକୁ ଆଣିଲୁ ସେ ରାତି
ଓଳି ଦେଇ
ମୁଁ ପଢିନି। ପଚାରିଲେ କାହିଁକି ପର ଝିଅକୁ ଆଣିଲୁ ସେ ଗାଡିରେ ପଢିନି।
ବଡ ବଡ ଝିଅକୁ ଆଣିଲୁ ସେ ପୋଡି ହୋଇ ମରିବେ ମିଛ କେସ୍।
ମିଛ କେସ୍ ତ
ମିଛ
ଲେଖା ହେଇଛି।
କେସ୍। ସେ କହୁଛି ପଚାରିଲେ କାହିଁକି ପର ଘର ଝିଅକୁ ଆଣିଲୁ ସେ ପୋଡି ହୋଇ ମିଛ କେସ୍। ତାପରେ ଆଉ କିଛି ନାହିଁ।
ଆଉ କିଛି ନାହିଁ।
Yes.
And my lordship, kindly have a glance to PW5.
PW5.
Yes. When my lordship, the marriage certificate has not been recovered, my lordship, but there is evidence that their marriage has happened in a Jagannath temple, which was proved by the PWs, my lordship. That part I just want to show PW5, my lordship.
Yes.
I know the accused person, accused Khakkan, is the son-in-law of my younger brother Sadananda. Daughter of the Sadananda had been given in a marriage with accused Khakkan out a year back. The marriage was held before the marriage officer Medinapur. Thereafter, it was also celebrated in the temple of the Lord Jagannath at Medinapur. Accused Khakkan stayed for 15 days in the house of the Sadananda after marriage. Cash of rupees 20,000, utensils and other household articles were given when he left Mittu alias Mani in the house of the accused persons. After a month, accused Khakkan and Mani came to the house of Sadananda. After 7 to 8 days of the her stay, accused Khakkan took Mani back to his house on the pretext that there had been snake bite. Young sister of Mani had accompanied Mani to the house of the accused person. Sadananda told that he had received information over phone from the accused Khakkan about the admission of Mani at Baripada hospital. Sadananda and his wife came to the hospital and I had not come to the hospital. I ascertained from the brother Sadananda that the Mani poured kerosene on her body and set her on fire. She died in the hospital during course of treatment. Then in cross-examination, I am living separate from my brothers. I was not present at the marriage, was registered before the marriage officer. On the date of registration of the marriage before the marriage officer, the marriage was also held in the temple. And the father of the accused Khakkan were present when the marriage was father of the accused was present when the marriage was held in the temple. Parents of the accused Khakkan came away after the marriage, but the accused Khakkan stayed in the house of the Sadananda. Mani stayed for 2 months with the accused Khakkan after coming from her father's house. I had accompanied accused Khakkan and Mani to the house of the accused person, Sam Sudha, and
who is he?
He is the elder brother of the victim's father.
Father, okay.
Yes.
Uncle.
Yes.
Elder uncle. Okay.
And that is corroborated with the brother of the victim also. The marriage was happened in the temple also. Same time, my lordship, it's very difficult to get the marriage certificate.
Yeah, registered marriage followed by temple marriage. Temple marriage.
They have the in-laws also attend the marriage.
It says neither he got the certificate, registration certificate or any document in the marriage. From the temple.
But temple marriage is there.
Yes.
Yes.
I'll be see the chief, the
No.
IO, PW11.
PW11. Yes.
I had also included Prabhat Kumar Kara, section officer, marriage registered officer, Medinapur. Manoranjan Chakravarti, priest of Jagannath Temple, Medinapur. I submitted that sheet after completion of investigation.
Para 4.
Para 4. Well, in paragraph 6, man. Medinapur headquarters is at a distance of 60 kilometers from the village of the informant.
I ascertained from the marriage officer that there was no such intimation concerning the marriage. On verification, I found that no such marriage had been registered in the office of marriage officer Medinapur. I ascertained from the temple authority that though the marriage is being celebrated there, but no record is being maintained. That's the problem. That's what she says, that the marriage was celebrated subsequently. It might not have been registered, but celebrated.
But that time in the year 2000.
And in the presence of the parents, and coupled with that, the 313 statement where all of them have said that they have accepted to be mother-in-law.
But these statement, what I have understood, but it should be, question should not be a complicated question, should not be ambiguous question. It should be straight. And if question would have been put in that light, then the answer would have been different. It has been time and again cautioned by Hon'Ble Apex Court that how a question under section 313 is to be framed.
Hey, 313 will be
a simple question.
There will be a additional factor, but see,
and
the PW5 coupled with the IO statement that there was a marriage taken place in the temple. That part is there. Registration part is not there. Registration part is not believed.
Not there. And no articles pertaining to the living of a lady in the house, that was not found. Nothing was there. When lady is staying as housewife, definitely some materials may not be like 10 sarees. At least 2 sarees would have been available for daily wearing, or any ornaments, any articles. Nothing is there. Articles seized from the house, and a question has been put, the dowry articles, and without understanding anything of the picture, these cannot be taken as the basis.
Yes.
Bereft of that, if the dying declaration purported to have been recorded by the additional Tahsildar will be believed, the husband or the accused has attempted to extinguish the fire. That is to be seen. On the last occasion, my lord, after hearing everything, was pleased to observe that if case of 490 or 304B will not be made out, can he be convicted for 306, because she has committed suicide in the house and admittedly in the house.
What was the charge?
Charge 490 304B by 34.
Yes.
Read in section 4 of the DPI.
Yes.
Conviction is for 10 years and 6 months fine. Now, out of the conviction, my lord, he was behind bars for around 6 years.
Already undergone.
6 years already on the conviction is 10 years. Because from 6/9 to 27/12, and again 29/10/2003 was released on bail 25/11/2008. Around 5.5 months. 5.5 years.
5.5 years.
Right. I think it's time.
Page number 33, my lordship, clause 32, the court has held how 304 attracted marriage.
The minimum sentence is 7 years. Yes.
Yeah.
Yes.
And my lord, if going little bit deeper, my lord, it will be same. Marriage, as it is, it was disputed. My lord, while recording the dying declaration, Exhibit 6, my lord.
See, let us see the dying declaration.
Madam.
Which page?
Dying declaration.
That is
75, madam.
Exhibit 6, madam.
70.
Page number 75. Before the additional Tahsildar come executive, the dying declaration says everything stated in the
In exhibit 6, let us see.
dying
Exhibit 6, madam.
exhibit.
Exhibit 6 प्रिंट आउट करेगा exhibit 6 ମୋ ନାଁ ଶୁଣଛୁ ମୋ ସ୍ୱାମୀଙ୍କ ନାଁ
ମୋର ସ୍ୱାମୀଙ୍କ ନାମ
3-4 ମାସ ପରେ ବିବାହ କରିଛି ବିବାହ ପରଠାରୁ ଯୌତୁକ ଅନ୍ୟାନ୍ୟ କାରଣରୁ ମୋର ଶାଶୁ ଓ ସ୍ୱାମୀ ମତେ ଅନେକ ଶାରୀରିକ ମାନସିକ ଯନ୍ତ୍ରଣା ଦେଇଛନ୍ତି ମୋ ସ୍ୱାମୀ ମଧ୍ୟ ମତେ ମାରନ୍ତି ତେଣୁ ଯନ୍ତ୍ରଣା ସହ୍ୟ ନ କରିପାରି ମୁଁ
Now crops up by a Bengali lady not acquainted with Oriya. Can she says in this language that their family members, those who have signed, they have also signed in Bengali. Apparently, see the language. More namas Muni Saspan, more Saminka Namu Kokon Saspan, book after.
But she doesn't say anything about the father-in-law.
No.
No, here the mother-in-law and
नहीं इसे कहीं कहा ना बहुत सासू ससुर होते
नहीं कହୁଛି କାରଣରୁ ମୋ ଶାଶୁ ଓ ସ୍ୱାମୀ ମତେ ଅନେକ ଶାରୀରିକ ଓ ମାନସିକ ଯନ୍ତ୍ରଣା ଦେଇଛନ୍ତି ମୋ ସ୍ୱାମୀ ମତେ ମାରନ୍ତି ତେଣୁ ଯନ୍ତ୍ରଣା ସହ୍ୟ ନ କରିପାରି ମୁଁ ନିଜେ ମୋ ଦେହରେ କିରୋସିନ ତେଲ ଢାଳି
ଡିବିରି
ଆଲୁଅରେ ନିଆଁ ଲଗାଇଦେବି
ମୋର ପାଟି ଶୁଣି ପାଖରେ ଶୋଇଥିବା ମୋର ସ୍ୱାମୀ ମୋ ଦେହରେ ନିଆଁ ଲିଭାଇଲେ ତାପରେ ମୁଁ ଆଉ ଜାଣି ନାହିଁ.
But here is
whether it can be believed, sanctity is there, definitely is there with regards to 32(1). But when a person is going to be penalized, relying upon this dying declaration should be above board. And to keep it above board, certain criteria are necessary. She was undergoing treatment while the dying declaration was recorded. PW8 says nurse was available. Neither the nurse has been examined, nor the treating doctor.
Yes.
Nor the treating doctor has been examined. To give a certificate, yes, she was capable of. Rather, the evidence of the doctor says she was out of tranquilization. A dying declaration can be introduced if there is no other case for the prosecution. It can be introduced at any time, but that should be free from any suspicion. Additional Tahsildar is quite competent to record the dying declaration, but he should at least call the investigating officer. Nurse was available. She should have been called. Doctor was available in the hospital. Nowhere it has been stated that she has approached anyone and he has approached anyone and everybody denied. Many a times,
let us come to 304B. You have been convicted for 304B, na? Let us see 304B.
To reach a conclusion to 304B,
304B excludes a situation where 306 is clearly made out.
Excludes. Because
completely
presumption is also different.
Because see, if it is an unnatural death relatable to the dowry demand, then 304B comes. If it is a death, admittedly a suicidal death, whether you can invoke 304B.
It
is a suicidal death because dying declaration is to be believed, then it is a suicidal death. She said that mu nije kerosene tel lagi mu mari. 306 is there.
Yes, they are.
If it is a suicidal death, admittedly a suicidal death. Can you bring 304B as a dowry death, even if it is relatable to dowry? Dowry, demand of dowry lead to commission of suicide. Whether it covers 304B,
No.
they don't cover 304. 304B is a death which is unnatural.
Unnatural. Not under
By
normal,
burn or by any
not
means,
under normal circumstances.
in normal
Here-
circumstances.
here
But here it is admittedly a suicide case.
Admittedly, they have
In the dying declaration, she says that I committed suicide.
Yes, they have
If
introduced.
once he committed suicide, then it comes out from the purview of 304B.
My lordship.
It should be 306.
But 306 is the abatement of the suicide. And if your lordship will say 304.
So it is
then
suicidal.
that-
That's what I'm asking. If it is, then abatement test has to be looked
Yes.
into. If it is a suicidal death,
It is-
admittedly suicidal, and there is a dying declaration to that effect, whether that will cover 304B or not, that's the question.
My lordship, kindly have a glance to the 304B,
Really?
the ingredients of the 304B.
Yes.
Where the death of a woman is caused by burn or bodily injury or occurs otherwise, then under a normal circumstances within the 7 years of her marriage, and it is shown that soon before her death, she was subjected to the cruelty or harassment by
Right.
husband or any relative of her husband or in connection with any demand of dowry,
Yes.
such deaths shall be called dowry death. And such husband of the relative shall be deemed.
Taken up Tuesday. Let my learned friend prepare it.
You answer it.
Yes.
My lordship.
Whether an admitted suicidal case can be covered under 304B.
But here, my lordship.
Then the test is different. Then abatement is there or not, all this test will follow. It should be in 304, if death caused by burn, injury or whatever
Yes.
unnatural way. But the death is of three, either it is suicidal or homicidal or accidental.
Yes.
If it is a homicidal death, unnatural, nobody knows how she died, you can bring 304B or and accidental case also you can turn around and say that it is unnatural, so therefore it is not accidental. But it is admittedly a suicide case. Then there should be specific
Charge also in there.
charge of 306 because there is a dying declaration to that effect.
But there is also, my lordship, in the dying declaration, she was saying she was subjected to the harassment, mental cruelty, my lordship.
I think you are not able to follow what I am trying to say. Whether if it is a case of a suicidal death, admittedly suicidal death, there is a dying declaration to that effect. Whether it excludes 304B or not. Only in that extent you read it and tell.
Completely ruled out from that.
Yes. It is a burn injury, no problem. She died of burn injury. But she herself says that I burned myself.
But the panel.
If it is unnatural death, unexplainable unnatural death, the presumption operates. Therefore, you are tried under 304. It is not an unnatural death.
Yes.
She herself says that I have committed suicide. Once she says I have committed suicide, how will you bring 304B? It has to be a specific 30. You can, bring abatement and everything, and you say that is 306 is made out.
That's one of the decisions, but that has been kept in the.
So that part you just tell me.
That was my.
This legal issue is to answer it.
Yes, my lordship.
Okay.
Yes, my
Okay.
lordship.
Next Thursday,
Yes, my
read it in that length. Yes.
Item 16.
Yes. 16?
Yes, I am for the appellant. Your lordship,
No, today is dedicated bench.
your lordship director.
Only I'll have to take up the matter from this list.
No, my lord, your lordship, you opened 10 people yesterday, but take up today, I am opening that paper will be not with me. But that day, on that day, it will not be elected. 1:30 day, 1:30 day, I will appoint it.
I'll take it tomorrow.
After recess, it will be better.
Dedicated bench I can't.
Tomorrow.
Tomorrow I'll take it up. In any case, you are there.
Tomorrow.
Tomorrow first item.
No, my lord, I'm sorry. Tomorrow I'm not available. That's why. Monday.
Monday, okay. Monday. Huh? Yes.
He has been already filed his note of argument. I have to file note of argument.
They are referred to.
You get the note of argument also.
Yes, ma'am.
Monday we'll do it.
Okay.
Okay.
Your Lordship will remember that they refer to her as citation under the purview of 133 and I refer to trust the endorsement.
Okay.
I have been
Check has been issued. Subsequently, it has been stop payment. That is the
not stop payment, refer to her. That's vast meaning.
Refer to dry.
Yes.
Yes, that is no. Check has been stop payment. I have been stop it. That the banks inform that
Refer to dry.
Dry.
Memo says refer to dry,
Yes.
but there is a stop payment.
Yes, ma'am.
That
That is the case.
Open that's vast meaning. It's a vast meaning.
Okay.
That is
But-
your question.
but yes. Yes.
26.
Yes, 23.
Conversation 365 and 366, 506 and 34 of IPC.
Yes. Yes.
May I read the explanation? And from the middle part of the affair, the informant stated that Devraj Reddy, crime branch police ସହିତ ଝାନ୍ସୀ ଯାଇ ଖୋଜାଖୋଜି କରିବାରୁ ଜାଣିଲି ଯେ ମାତିଆଣୀର ସ୍ୱାମୀ ଜୟ, ତାର ମାଉସୀ ପୁନି ଓ ତାର ମଉସା ରାମ ଦାସ 12,000 ଟଙ୍କା ନେଇ ଦୁଇ ନାବାଳିକା ଝିଅକୁ ଗୀତା ଓ ରୀତାଙ୍କୁ ମଧ୍ୟପ୍ରଦେଶରେ ଜିଲ୍ଲାର ସିମିରା ଥାନା ଅନ୍ତର୍ଗତ ଘରୁଆ ଗ୍ରାମରେ ସୁନ୍ଦର ରାଜପୁତ ଓ ପରଶୁରାମ ରାଜପୁତଙ୍କ ସହିତ ବିବାହ କରାଇ ଦେଇଛନ୍ତି। ଝିଅମାନଙ୍କୁ ପାଇବା ପରେ ତାଙ୍କଠାରୁ ଜାଣିଲୁ ଯେ ମାତିଆଣୀ ପ୍ଲାନ୍ କରି ତାର ସ୍ୱାମୀ, ମଉସା ଓ ମାଉସୀଙ୍କ ସହ ପଠାଇଥିଲା। This is the statement of the complainant.
Yes.
And again, the 161 statement of the complainant, my lord.
What will you do with 161? Let us come to the evidence now.
Yes, my lord, there is no
Have you prepared a written note?
Yes, my lord.
So give me. You prepared it for yourself or you want to give it to court?
Yes,
You want to give it to court or
Yes,
is it
my
for
lord.
your opinion? Yes.
My lord, there is no independent witness to prove the charges of 375 and 366.
Hmm.
And the exhibits are also not prove the charges of 365 and the exhibits, ma'am. The exhibits are also not proved.
Go systematically. One sentence from here, one sentence from there, nobody will understand. Who is the victim?
The victim is
PW?
one second.
You have to systematically argue, not that one sentence from here, not one sentence from there.
Victim is
Who is
Rita
victim?
Patra and Gita Reddy.
PW?
PW 3 and 5.
Let us read 3. What is the allegation against you?
And 365 and 366
Yes.
kidnapping and forced to marriage.
Yes. What is the facts? Prosecution case.
And prosecution case that the two appellants are kidnapping by
kidnapped this victim girl.
Kidnapped this victim girl.
PW3.
Two victim girls. Yes.
Two victim girls.
PW3 and
PW3 and 5.
PW3 and 5 kidnapped, huh? PW3 and 5. Okay. They were kidnapped and
For sale in Jhansi,
for selling them.
selling them Jhansi
Hmm.
for rupees 12,000.
Hmm.
And marriage to one Sundarlal Rajput. Geeta Reddy marriage to Sundarlal Rajput and Rita Patra sold to Pasuram Rajput.
Let us see now PW3.
Yes.
What does she see?
Deposition of the PW.
You don't have deposition.
Yes.
Read it. Have you prepared or not properly? Yes.
I know all the 5 accused persons present in the dog informant. The informant Basanti Patra is my mother. The occurrence of this case took place 1 year back. My sister Pramoda Patra married at Kotra of MP. And previously, the another informant, the mother Basanti Patra, PW3 ର mother ହଉଛି ବାସନ୍ତୀ ପାତ୍ର. ତାଙ୍କର ଗୋଟେ elder daughter ବି ମ୍ୟାରେଜ କରିଥିଲେ ଝାନ୍ସିରେ, କିନ୍ତୁ ତା ପାଇଁ ସେ କିଛି କମ୍ପ୍ଲେନ କରିନଥିଲେ. My sister Pramoda Patra has married at so and so
Kottara of MP to one
Indupar. She has been staying there when I went to bring water from the well near the house of Matiani. She told me that my elder sister Pramoda feeling lonely and wants me and I should go there with her. On the next day morning, myself and one girl, Geeta Reddy, and another victim had been take bath. Joya came to our bath place and called us to go for doing work. We both went with Joya. Joya hired an auto, but the auto driver
denied
to take us in his auto. Joya took us to a shop situated near Xavier. He took us in an auto to railway station and kept us in one bathroom. Punni reached railway station. Both Joya and Punni took us in a train and took us to Jhansi. There we stayed in the railway station.
Stayed in the
railway station in the night. From there we both were taken in one auto to Jamunia. There we both were kept for 8 days. And there I was given in marriage to one Pasuram Rajput for 12,000. Rita was given in marriage to Sundarlal for 12,000. We both wanted to go away, but the said person Pasuram and Sundarlal told unless they get 12,000 each, we cannot go anywhere. They told that our Mausi Punni has taken those 12,000 for each of us. In the meantime, we were preparing to take poison. Lady police officer along with Devraj Reddy arrived there. They brought us from the possession of the accused to Noyapalli.
Who is Devraj Reddy?
Devraj Reddy is the informant and the father of Geeta Reddy, the PW5 victim.
Okay.
Anything in cross-examination? You proceed.
Yes, ma'am.
What is your case? You have to,
Better, my lord, let me come another next week so that you prepare.
you prepare properly. What is your case? What is your case?
And my case is Mafia and Sampad, the accused number 1 is knowingly involved in this kidnapping and selling the gas. And there is no proof of transaction of money, ma'am.
Have you written all these things here? From the written submission, one after another, you have to read and substantiate that from the evidence. Like the failure of the prosecution to prove the age of the alleged victim. You have pointed out something. From the evidence, you show me that. Thereafter, you have noted that ingredient of section 365, 366 is not established. What are the evidence towards that? What are the ingredients? You have to tell me. Likewise, you have to argue. You prepare a very good note, but you have to structure your argument. You structure your argument and tell me. Okay. You have this written note of submission is very good, but the written note of submission you read and one after another you focus. Okay. Thereafter, which matter? 30? 33. Okay. 33.
It will be taken up next week.
It will remain in the board. Get ready.
Seven part.
7 key.
My lord, I have no power.
You?
I have no power in this.
I will appoint you as amicus.
Yes.
Right, amicus. Today I will appoint you amicus. Yeah? Give your name.
On behalf of
Yes.
the
I will appoint you amicus. Yes. Yes. Then parted. Item 6.
Item 7.
7. After 7, then 33. Okay. 7 and 33 are there. Seven, huh?
7.
Yes. Yes.
The present appellants have preferred to settle the order of conviction wherein the appellants have been convicted for allegations under section 307 and 323, wherein they have been sentenced to undergo imprisonment for 3 years.
Yes.
Lordship may kindly have a glance at the finding in the DCR it's given at page 57.
Yes. Yes. Yes.
That is the brief facts of it. The synopsis of the case is that on 5/3/97 at 8 p.m. Udhav Naik of village Sunjar, place Sadar, presented a written report alleging to the effect that his father, Bhima Naik, carrying on Fajuri Tadi business near his village on Q3/97. Ramesh son and one Binod Raksa of village Olikira had been to that place to consume that. During this, there was a quarrel between his father and Vinod Raksa, during which Vinod gave threatening to set him right and return without taking Tadi in the night. On 3/3/97, while his father was sleeping inside temporary shed, Vinod Raksa and others assaulted his father, entering inside the shed by means of sharp cutting weapon instruments and causing severe bleeding injury on the head, hands of his father. Receiving this information, he immediately rushed to the place and shifted his father to the government hospital Sundargarh for treatment. The occurrence has been witnessed by one Stilas Bagas, who is PW4 Lodge.
Yes.
He was alone. He reported the incident on 5/3/97. On this, ASI PN Patil took up the investigation of the case and subsequently took charge of the investigation from him. During investigation, it came to the light that the father of the complainant is carrying a tadi with accused Ramesh Sahu, who was the GR of the PS, was helping him for the said business. On 2/3/97, accused Ramesh Sahu and Asaram Sonda of Alikira went.
Come to the evidence. Why are you reading back?
I will show the differentiation because it has been categorically stated by one Vinod Raksa assaulted him. But Vinod Raksa has been.
Who has said that?
In the FIR, it has been stated. And Vinod Raksa, the peculiar part is Vinod Raksa has been given clean sheet in the charge sheet.
Okay.
He has been given clean sheet. And Asharam Sonda was not named in the FIR.
Yes.
But in the IO's evidence, he has categorically stated that Vinod Raksa is the same person as Asaram Sonda. But in the charge sheet, he has been given clean sheet. Both the
There is a mistaken identity.
Yes, sir.
According to you. What PW3 says?
Lordship, can you answer PW?
Yes. Let's see PW3.
PW2 is important. 3 is
3 is injured.
He is injured, but she goes unconscious hit but 2 is the eyewitness supposed to.
I think his category stated that Asaram Sonda assaulted on his left shoulder.
Let us see that. Let us see what is. 3, huh?
3, right.
I know that.
I slept. I have not seen the assailants who assaulted me as I had slept. I sustained injury on my head. My wife had seen the assailant who assaulted me. PW2 is the wife. Let us see the PW2.
I know the accused person who was standing in the dock.
Injured Vima is my husband, and the occurrence took place in Falguna Master so both the accused persons had taken Khajuri Rasa and they were in the state of intoxication. The Vima Ramesh Sahu assaulted, Ramesh Sahu, appellant number 2, assaulted my husband by means of a knife. Accused Asaram Chanda assaulted my husband by means of a lathi. I ran away from the village and so on. So I returned by so on. So yes, they very categorically taken the name.
But there are so knife injuries.
Let us see. Then appellant number 2 has given a knife injury and one has given a lathi injury. That's what is the eyewitness says. I saw the assault of my husband by the person. My husband is sustained injuries. Yes, I am reading para 2 cross examination injury, and he had sustained injuries on my left hand, and he has sustained about 6 injury on his head and face, and he has also sustained injury on his waist, and rib of his hurt were also fractured, and he has sustained bleeding injuries on his person, and the blood coming out from the place of injuries, and there was blood sustained places of occurrence also. Yes. Ramesh have assaulted my husband by means of a knife. Again reiterated, para 3. Ramesh Sahu assaulted my husband by means of a knife. And it's not a fact that yes.
Document annual that para 4.
Para 4, okay. Para
There
4.
was no
Electric light in Puria, and there was no electric light in Hot. So, current both the accused persons belongs to the different village. I know both the accused persons since long, and it is the fact that not pulling on well and so on. So yes. You have only say that the electric light. Where is the question saying that the light was not enough? You have not seen. Where is that?
that is an observation also.
Because of the bad cross
Oh, then bad cross-examination only elevates.
That is the in trial, whatever you put in
Where
trial-
is the suggestion saying that you have not seen?
But he has not stated that he was.
Why should he say? It is you have to get it from the cross. No. You simply ask the electricity was not there. It's all right. Your intention is to show that you have not seen. But that question is not there. There is no suggestion also to that effect. Then forget about that.
Trial court observed this in his judgment regarding to the.
I have not seen that. That obviously, that is the obvious thing.
And in fact, regarding the statement of PW.
Let us see the doctor now.
Ultimately, there are number of injuries.
9 number of injuries, 2 grievous injuries there.
And no knife injury is there.
Let us.
No knife injuries there.
Let us.
ସେ 161 ରେ କହିଥିଲା ଯେ ଧରିଛି କିନ୍ତୁ ଏଠି କହିଲା ଯେ ସେଥିରେ ସେ ମାରିଛି ତ ସେଇଟାକୁ ଇଭେନ୍ ଲୋର
Let us see doctor. Let us see the doctor. Let us.
PW2 has not been taken by the.
Who is the doctor?
PW5.
5. Okay. Let us see.
On 4/3/97, I was working as casualty medical officer DHQ Sundargarh. On that day, the police.
All of them are completely intoxicated.
Yes,
And these people kept on giving blows. Lacerated wound, injuries also. There are so many injuries, Bob.
9.
So many injuries. Injury had kept of it in reserved. Injury 1 to the patient still underwent treatment. In conditions of being current low BP record. 5 and 6 are grievous injuries. 9 is simple. All injuries have been caused. Yes. What is your case?
The first point is Vinod Raksa is he was given clean sheet, but the IO in his cross examination categorically states that Vinod Raksa is Asaram son.
Let us hear you.
Yes. Pidolate.
Pidolate.
Para 8 ku asundari.
Which para?
Para 8.
Yes. From the paper slip epics.
Written from first, third, second paragraph onwards, Lordship, because there are many contradictions regarding that aspect.
No. First, you show me that name confusion.
Main part is para 8, Lordship.
That's what. Vinod Raksha. It's the fact that in FIR, one Vinod Raksha
was
alleged to be present with the accused Ramesh Sahu.
But
the said Vinod Raksha is
other name of
accused Asaram.
But in the charging, he has categorically given clean sheet. Now that.
But he has not given clean sheet to the Asaram.
If he says that Asaram and
Vinod are the same person.
Baksha, what is that? Baksha. Vinod Raksha, one and same person.
One and same.
And if he is giving clean sheet to Vinod Raksha,
yes, Lordship.
Then how will you bring Asaram?
Your Lordship, can you see the final form again?
Final form.
Page
57.
57.
What page? I don't know. In Oriya it is written, huh?
No. Final form is the brief factor जो था 57 pages.
1 minute. Brief facts. Yes, brief facts. Yes. Synopsis and the case and so on. So during this, there was a quarrel between his father and Vinod Raksa, during which Vinod gave a threatening to let him so and so. What is it? During the investigation, it came to the light that the father of the complainant is carrying a tardy business, and Ramesh Sahu, who was the engineer with PS helped for the said business, and afternoon Ramesh Sahu and Asaram Sharma, son of Akshira so near Bhima, and asked him to study to which where does it say that Vinod Raksha has
forthcoming against Vinod Raksa, last line.
Where is that?
And he has categorically.
Then where is that?
Last line, Lordship. No evidence
Yes.
forthcoming against Vinod Raksa in this. Or else he should have mentioned that Vinod Raksa is the same person as Asaram Sandhu.
Yes.
Only this line, Your Lordship. But in the during investigation, he himself
After investigation only he has filed. He has not gone a special knowledge after the charge sheet is filed.
No, Your Lordship. Say that actually. Yeah, actually say the same line that lekhi ଦେଇଛି କିନ୍ତୁ ସେ ଜାଣି କାରଣ ସେ during investigation he came to light that Asaram Sandhu ହେଉଛି main culprit ଯୋଉଟା କି ତା ନାଁଟା ଅଛି ଯେହେତୁ FIR ରେ ସେ ବିନୋଦ ରାକ୍ସା ଲେଖିଛି ସେଇଟା ପାଇଁ ସେ ବୋଧେ ମେ ବି ଲେଖିଥିବ କିନ୍ତୁ even in Pidol 8 in his cross examination he is not put any question regarding to in charge sheet you are saying that this person has known how you now you can say that this
Let us see PW6 again.
Pidol 8
IO. PW
Your Lordship.
8 na?
Yes, Your Lordship.
Have you cross examined him?
No.
Have you said that you are
Yes.
Vinod Raksa is not a different person?
No.
Where is that?
No.
Then
No cross-examination.
then
And another aspect is
the summary made by an IO in the charge sheet is neither here nor there. It is his opinion. We have to go by the document and evidence 161 statement. He might have written, suppose 161 statement and all documents speak something else and the IO writes something else. On that basis, can the case be decided? This is IO is the next. IO writes a summary, a synopsis of whatever he has got. Suppose he has written wrong. Suppose he has written something which is contrary to the documents enclosed with the charge sheet itself. Can that be taken into consideration? The documents are important, not his summary. It is his opinion.
Right.
It is like a forwarding letter.
But
If there is a charge sheet, right? If the charge sheet, so this Asaram Sandhu.
So no. If that was the case, then in the cross examination you should have nailed him down.
Yes, Your Lordship.
Saying that in the charge sheet you have said.
The cross-examination.
You should have asked him in the charge sheet you have said no case is made out against that Raksa, whatever Raksa.
Yes.
Then how come you are saying that Asaram Sandhu?
Now where is that question? Where is that suggestion?
But it has not been taken. Plea has not been taken. Lordship, and another aspect. As per the IO, one Silas PW4 has seen the occurrence.
Yes,
He is an independent witness.
Now
He didn't support.
no.
But
Lordship, I will glance at the chief Lordship.
for 4,
PW8
8, okay.
during the investigation from para 2 onwards.
Para 2, okay.
During the course of the investigation, I examined the informant and issued a requisition to the doctor to examine Viman Naik, who by then had already been taken to the government hospital. Exhibit 2/1 is by requisition. Thereafter, I proceeded to the spot near the date farm where the incident had taken. The informant with whom I had gone to the spot showed me the lathi and said that the said lathi was used by the accused person in the airport. I seized the list. I seized it by seizure list exhibit 4. The lathi was 4 feet long. MOI is the said lathi. On 11/3/97, I arrested both the accused person from the village. During investigation, it came to the light that injured was member of Gonda class. As such, I read the SDGM to the church. Not to become a paragraph. It is a fact that Viman Naik entered before
That on 3/3 night, while himself and his wife were asleep,
Yes.
both the accused person came there and out of the accused Asaram assaulted him over the left hand by giving 2 lathi blows.
and subsequently he didn't support that. He said that after being hit, I lost my consciousness.
Stated before me that but PW1 and 2 evidence stands corroborated with the evidence of a doctor.
Doctor, PW5.
How will you get over that? Minor discrepancy here and there are there.
Look, the light part is one of the major discrepancies and one of the
Light part is unless you ask that question specifically.
cross-examining that.
That will not.
That even in judgment, the trial court dealt with that.
You have not asked that it is dark, what was the distance, it is visible or not. Nothing was asked. Light thila ki nahi? Light nathila. But that's all. Then you imply everything. You should have asked what was the distance, whether it was visible or not. Anything of that sort. Unless you make out as a case that it was not visible, it was dark night.
And PW2 happens to be interested witness. But PW4 was the independent witness as turned outside. In that aspect, Lordship.
Very, very weak points you have. Now come to this real substance. How much you have undergone?
10 days, Lordship.
10 days.
In
307.
that aspect, I'm citing.
It's not a case for acquittal. That's the problem.
Benefit of the act, best benefit of.
What benefit? How will I discard PW 2 and 3?
Discrepancy in the evidence of.
What kind of discrepancy? The discrepancies are not.
In the ninth aspect, Lordship.
Huh?
Ninth. No injuries of ninth.
Okay, that is one discrepancy.
Like which was produced before the court was different from which the IU has seized another line.
Where is that? How? Where is it?
Cross-examination.
Of
I had only seen one line.
Nine.
7.
7. Yes.
The other lathi which is sent to the court was not seized by me.
The case diary also doesn't reveal the seizure of the lathi by inspector in charge. And it is also the fact that I had not examined Neelu Godia PW6, and it is not the fact that so and so. And the knife is not seized.
No.
No injury with the knife also.
No injury with the knife.
Knife. No.
The lathi is supposed to have been used. There are confusion. 2 lathis now there.
Admitted. ସେଇଟା ହିଁ ତା କେସ୍ କେବଳ ସେ ସେତିକି ଲାଇନ୍ କହିଥିଲେ ତ ମୁଁ ସେଇଥିପାଇଁ ଜାଣିକି ସେଟା ପଢୁନି ପୁରା ମୁଁ ଏଇଠୁ ପଢେ
That is the only case.
That is the only case.
Why are you going here and there? Now,
ସେଇଟା 6
whether
to start
injuries are there.
ତା କେସ୍ କେବଳ ସେତିକି
Injuries, head injuries, huh?
ଫ୍ରାକ୍ଚର also there.
No, I was convicted to 325 and reduce the sentence. Because see, you can very well say that the intention was not there because it has come on record that they were completely intoxicated. They had no intention to kill. They, in an innervated condition, they have attacked. And they attacked by using lathi or knife. All these things are confused together for all these things. So in that view of the matter, we can very well say there was no intention. It was a spontaneous attack, but in the same time, since injuries are there, and both the witnesses are saying injuries are being sustained by them at this instance, at the instance of the people. But what kind of weapon used by them is not coming forth clearly, and they were intoxicated. So therefore, intention part can be removed. If the intention goes, then since it is grievous hurt, 325. 325, then sentence you tell me now. 10 days you have gone. I can reduce the sentence. But there should be some sentence. 325. Max to max, we can try and do this. When the incident happened? 2000.
Also 90s.
Incident.
397.
97. When was the amendment?
97.
Huh? So if you 326 if you do, then probation can't be given. It should be 325. Probation with some fine.
Right.
See, 324 you can't bring because voluntarily causing hurt by dangerous weapon. Weapon has to be taken out. So 323 you can't do, it is not simple injury,
it's not.
grievous injury. 324 we can't do because weapon is not sure what kind of weapon they have used. 324 goes. And then comes to 325. Only 325. If you go beyond 325, then POAT is not applicable. So 325 is the only option left.
Right. This is going to get punishment, get paid, you know.
Voluntarily cause grievous hurt, so punishable imprisonment with the very description which may extend to 7 years. And shall also be liable for fine, both. Both. We can impose. And section 5 also we can think of imposing. So you in the written note of submission, what have you said? Let us appellant. Yes. The first point is knife
regarding
injury not there. ठीक है? First is knife injury is not there. Second, knife is not recovered. Recovered. Third is lathi to which paragraph you've shown? PW 8 para lathi. Para 7 lathi, Para 7 lathi. PW 2 and 3. PW, doctor is PW
5.
5.
add
PO plus fine. Then this is what ultimately it comes out to be. Knife injury is not there. Knife is not also recovered. And lathi do recover, but some other lathi was produced before court. That shows from para 8 to PW 8, para 7. So weapon of offense is not proved. Which weapon of offense is used is not proved. And intention is not there because they were all intoxicated. And even the injured himself doesn't know who is assaulted. Okay. Injured is PW?
PW 3. PW 3 is injured, PW 2 why?
ठीक है जी. Then 325 convert to 325 provision along with fine. ठीक है. Evidence. ठीक है. Evidence, हाँ? PW 2, 3, 5 and 8.
The judgment regarding which observation regarding darkness टा होची 0.9 ने से ଦେଇଛନ୍ତି तब regarding knife look जोटा नहीं सेटा से सही 9 ने ଦେଇଛନ୍ତି ଆଉ 12 ରେ होची PW 5 रो तार डॉक्टर रो तार स्टेटमेंट as well as delay of FIR एति जिंस होची ଆଉ ଗୋଟେ ଆଲିବେଲି କହୁଥିଲା ଯେ ସେ ଆଲିବେଲି କହୁଥିଲା ଯେ ସିଏ ନଥିଲା in that person in 313 ସେଇଟା ହଉଛି କରିଛନ୍ତି ପାରା 13.
That we will not go into elevate. Yes. 33. Yes. Yes.
Immediate superior officer of the that department in mandatory clause section 42, 54 has not been confirmed.
Let us concentrate on 42, 50 and 54. Whether it did not comply, show me the evidence first.
The independent witness by the time of substance seizure, they have not supported the prosecution.
That is not. An independent hostile does not mean the entire case will.
Independent witness in the all NDPS case, the story is same.
Same.
Seizure witness never supports. That's the same story. You need not see that. And the conviction is based on all the evidence of the official. Almost all 99.9% cases.
He has not supported. That is the vital.
Who has not supported? Who is he?
Working man. Working man.
Yes.
Work.
Seizure witness. Let us see.
I was approached by the partner case from the end of Ganja and reported to near there were collected, there were 3 airbags where Ganja was kept. I waited those Ganja and collected 50 grams sample from fish. Those separated sample were kept in cages.
Police seized my weighing something.
Here in front of Marshall, when I reached, I did not find anyone there. I will have brought those articles to Maharashtra case. Those articles were there. I was asked to wait the same. Thereafter, they have took 6 signatures from me on different format paper. I do not know the content of those papers. I will have kept those one thing. I do not recollect the exact approximate weight of the article, which I do.
I have no idea about the ganja.
Yes, ma'am.
Except the work thing. He has only weighted. Weighing.
Only that.
He may not have idea about ganja.
He stated that the Indian procedure was fully stated, whereas the I stated and other witnesses have stated that at the time of spot.
At the spot, everything has been.
Yes,
okay. Done. Okay.
That department would be having.
Where does it say this weighing and the ganja and collected samples?
Where does it say that it is done in the Havildar took 6 signature from
No, no,
the?
where it has stated that in
I did not know the
it was the
content
police
of the
station.
Havildar took did not recollect the get. Havildar brought those articles to Madhepur PS, and those articles were opened there by the Havildar, and I was asked to read the same. Okay. The second time it was done, the spot I accompanied him to so there
No. 3 and 4 are stated for the
was kept.
3.
No,
3
just
and
the
5.
examination chief. What he says is there once the weighing was done there at the spot. Again, it was brought to the police station. Again, it was done. The examination chief. At about 6 months back, I was approached by Havildar so and so for weighment of the some ganja, and accordingly I accompanied him near Macho Godam of DC Marvel. There were 3 airbags where ganja was kept. I weighed those ganja and collected 50 grams of sample from each bag. Weighed there. There the spot it has been done. Again in the cross examination, he says the Havildar brought those articles to Madhepur PS and those articles were opened there by the Havildar, and I was asked to weigh the same. And the second time again it has been done.
Yes.
Yes. But what you are trying to project is that everything has been done in the police station. But it was done earlier also there in the spot. Yes.
There was signature was in the global examination final we decided that no such signature was
There.
sample collection symbol.
Which PW8. Now you said 42 is not complied. How do you say 42 is not? PW4 is the diocese. Police station, but he says that at the spot also it is done. Next point is 50. Come to 50. Come to the evidence first. Come to the evidence.
Evidence of PW8 madam.
PW8.
Yes, sir.
Yes.
Who is the investigating officer?
Yes.
On 9/5/2005, I was working as district police office in SR section. On that day, on my production before SK number IO, 2 report under section 42 and section 57 of NDPX Act were settled, and I was signature PW8. I cannot say the content of those documents I seized on my production. It is not a fact that nothing was seized in my presence, and I did not produce any of them.
Abhay Kumar Ponda.
Abhay Kumar Ponda. On 17/3/2005, I was working in the present capacity. On that day, around 7 a.m., IAC called me and other police personnel, including ASI and such, informed me that he received telephonic report that 3 persons arriving in Khannagar area carrying contraband article like ganja, and accordingly directed me to lead the above named police personnel to have raid and detection of the possession. Accordingly, command certificate was issued in our favor. Thereafter, we proceeded to Khopuria on wax from Madhupatna PS. On the way, we
we proceeded two independent witnesses, namely Purna Chandra Biswal and Prashant Kumar Mohanty. They have been hostile, my lord. After appearing them about purpose, when we were waiting near the press circle in front of marble shop, we saw these three persons identifying the accused person were there, coming on walk, each holding airbag on their shoulder from Khannagar Mani Mandir side. It was around 7:45 am. We intercepted them in front of TC Marble Shop after disclosing our identity as well as information received by us. When I inquired as the identity as well as the possession of contraband article, the accused person disclosed their name and identity and confessed to have carrying the in ganja. Thereafter, I offered in writing in three separate sheets separately, seeking their option for their personal search.
See, I offered them in writing.
Yes, ma'am.
In three separate sheets.
That I don't dispute.
Separately seeking, yes.
That is the executive magistrate or gazetted officer. The accused person agreed for their search in presence of gazetted officer. As the accused person are illiterate, the witnesses scribe the opinion
And read over.
Yes, my lord.
And explain.
Yes, my lord. That is the main thing, my lord. They are illiterate. The independent witness, they have turned hostile. My lord. What I wrote to law.
The witnesses, those who have signed the
yes,
that written no, they have turned hostile. Let us see the exhibits. Let us see the exhibits.
13-1. Exhibit 13-1, 14-1 and 15-1.
Where is that note written?
Exhibits are, my lord.
Exhibit
13-1, 14-1 and 15-1 are my signature. Exhibit 13-2, 14-2 and 15-2 are the signature of witnesses. Purna Chandra Biswal. The accused person also gave their consent on the above paper exhibit 13, 14, 15 for their search in presence of the gazetted officer. They are the illiterate person, my lord. Illiterate tribal person.
Montu Prashant Mohanty and Purna Chandra
Biswal. They are the independent witness. On their presence, my lord, the accused person gave their consent. That search is to be made before two independent witnesses. They have been turned hostile.
Yes.
Constable Ravindra Kumar Pradhan was sent to PS with a requisition for deputation of gazetted officer to spot. In the meanwhile, Havildar Dharandhar Naik was sent to collect women men for weighing contraband ganja. Krupa Sindhu Sahu with women scale and unit to weight the contraband article. City DSP Kumar Mani Meher come to the spot being a gazetted officer. The DSP, who is the immediate officer of the IO, my lord. On arrival of Sri Meher, I introduced him to accused person. Thereafter, personal search of mine and other police personnel was effected. Thereafter, personal search of Kumar Mani Ganta was effected on his personal search as well as the search of airbag held by him of navy blue color. It was found that the bag was containing ganja wrapped in a polythene paper. When the airbag was weighed, it was found 13 kg, where the net weight of ganja was found 12 kg in sample. Each weight meant 50 grams. This is important, my lord. Where who has weighed the article, he stated that was done at police station.
Two places.
Two samples were drawn.
Were collected for the said ganja, and thereafter the bulk ganja in the bag and sample ganja were sealed after the proper packing in polythene. Sample ganja were collected in two separate polythene, a paper seal carrying in my brass impression and signature of witness myself. The accused DSP were kept in those polythene, and thereafter the polythene was again kept in a paper packet, and the paper packet was closed and sealed with my brass seal. The bulk ganja being kept in airbag which wrapped with gunny bag, and then gunny bag was sealed with my brass seal. Inside the bag, a paper slip containing impression of brass seal signed of the accused DSP witness was also kept. The Xerox paper slip was kept inside a airbag. The bulk ganja in airbag was marked at Exhibit 1, whereas two other samples were marked at Exhibit 1 by 1. And AY2, accordingly, seizure list was prepared in respect of two above seizure from Kumar Mani Ganta. It was read over and explained to the accused and the witnesses. Their LTI and signature were collected Copy of the seizure list was furnished to the accused Kumar Manikanta in DSP, and I were also signator to the signature list. Exhibit 1/2 is the signature list, and Exhibit 1/4 is my signature thereon. Exhibit 1/5 is the signature of the gazetted officer. Similarly, on personal search of Desi Ganta, this same thing was continued for accused number 2, my lord.
Yeah.
Similarly, on personal search of
Yes, where exactly the sample was drawn? In the spot or in the...
that is the doubtful, my lord. That is the for thereafter.
If you believe PW4, he says that it was done at the spot and second time again it was. Second time, why it was open? He says that the Havildar opened it in the police station. Why was it done?
But the PW8, the IAC has their deposition. The accused persons disclosed that thereafter I offered in writing 3 separate shifts seeking the prior option to their personal search, either in presence executive magistrate or agreed search and presence of the guested officer. Accused persons are illiterate. The witnesses Prasanta Mohanty scribed the.
So therefore it is not coming clear where it exactly has.
That's that clear from that. But no, that.
Which part? And PW4 is the independent witness. What about the other officers, those who have gone? PW5?
PW5, PW9, 10.
Let us see PW5, what does he say? When you wait to the witness also, another procured. We intercepted the accused persons standing in the dock, identified while they were coming with the airbag from the so-and-so, suspecting the airbag containing so-and-so, the accused persons explain about their suspicious movement to those of the residents of the building so-and-so, whether the
sample was collected from the spot, para 2.
So, the accused persons offer their search in presence of the gazetted officer. Panda Babu sent the constable to call the gazetted officer to the spot by giving him the requisition so-and-so manner, and after our so-and-so arrived at the spot, we will identifying the accused persons and sought their opinion. And if they were willing to vote so-and-so, the accused persons agreed for the search in presence. Thereafter, when the bag were searched, they were found to have contained ganja, and hence I sent, I was sent to call a weighman. I brought one Upas into PW4 to the spot with weighing scale and unit of so-and-so. On the weighing ganja recovered so-and-so, same much found so-and-so. The ganja is so. The sample was well selected for each bag. Sample ganja were separately reserved. And from his evidence, it appears that everything has been done in the spot. But come to again 4. Again 4. 4 also in the examination chief says that everything has been done in at the spot. But when you come to cross-examination, just read the cross-examination again.
These articles were open there by the Havildar, and I was asked to weigh the same.
Why it was open?
Even if the second time it was opened and
once you open it, then it is compromised. The sample is compromised. How will you explain it? Everything is done at the spot, no problem. But once it was brought to the police station,
and it was,
there was no occasion for reopening it. Once it is reopened, there is a chance of,
Doubt. And
compromising the samples.
temple that subsequently nothing found that anything has been tampered with that.
No,
In their
What
presence,
is the
everything has
result?
been
What
done.
It is a matter of, creating doubt only. Because strict procedure has been followed. And this is, thereafter, they having the two signatures from, on different papers, I do not know all these things. It was open, how it was open. How the trial court deals with it?
Trial court
Let us
overlooked
see.
that, my lord, and your
High Court, trial court, insofar as
findings of the
PW4,
page 16, my lord.
page 16.
Page 16.
Let us see.
One thing I want to draw your lordship, my lord. From the bottom line, the order dated 18/3/2005
1 minute, one page.
of the court of SDJ.
Which paragraph you're talking about?
That is continuing paragraph, my lord. The page 16 is this.
16, okay.
Yes, my lord.
Yes.
In between, the order dated 18/3/2005.
At the top, huh?
Yes, my lord. The court of SDJ Kotak indicate that the seal packet exhibit.
No, I am not able to find it. This paragraph start. This is the paragraph 10. Part of paragraph 10.
Page 16, my lord. Paragraph, sorry. From the top line.
16 at the top, huh? Their signatures are also available on the seizure list of the exhibits.
The order dated, my lord, kindly have a glance. Order dated 18/3/2005 of the court of SDGM Kotak indicate that the seal packet exhibit.
No order dated. Nothing is there order dated. Which paragraph? Just see which paragraph.
No, my lord, this is not a paragraph.
Read the paragraph must be there.
Which page 16, my lord.
Tell me the paragraph.
No, my lord, there is no paragraph, my lord.
I know that, but it's part of which paragraph?
Yeah, from the top line.
Part of which paragraph?
Sorry. 8. Para 8.
Yes. Para 8.
8.
You tell that.
No, my lord. Para 9 it is.
Para?
9. Para 9.
Para 9.
Para 9.
Okay.
Continuous para 9.
Para 9.
Para line, page 16, from the top top line 10.
What is it? Page 15. Page 15.
Page 16.
You are reading from the paper book?
No, my lord, judgment. I marked it.
Sir, that is a paper book. Want to start on it?
The RFS report, my lord. The RFS report shows that, my lord, there was no endorsement whether the sample was sealed or intact.
Yes, take it. Yes. Which part you are reading? You are reading the order date.
Yes, ma'am.
The order dated
18/3/2005
to 1995 of the Court of SDGM Kotak indicates that the seal packet of so were produced in the court on the very day when the accused person
were forwarded
and prayed for the transmission of one of the set of the samples to CFHL. The chemical analysis, hence merely
no certificate being given
certificate
in the order of effect that the seal was verified and found intact. There was no certificate, my lord.
No certificate.
Yes, my lord. Whether the seal was intact or not. That the RFS report has to be furnished.
Sample was yes.
Hence, merely no certificate being given in the order to the effect that the seal was verified and found intact does not suggest that the sample packet were not properly sealed. The order further indicate that on production of other exhibits, direction was given to the IO to deposit the same in the Sessions Malkhana.
So what he is trying to say is, since there is no certification,
yes, ma'am,
seal were intact or not, coupled with the fact that it was compromised in the police station, reopened, it creates a doubt.
What is the reason? What is the occasion to reopen in the police station?
Yes.
The PW4 dealt with by London Trial Court as page 8.
Page 8. Yes. That the part might have been escaped.
In my paper book, 2 pages, page 13, 14 is missing. That's why it's cause problem.
13, 14. Just see, check it from here.
Page 8 making a glance.
8 years, read it.
Internal page 8 of the judgment.
Yes.
Last but to one line. Although starts from although. Although P4
Very
is
difficult
not
to read, but let us see. Although read it.
P4 has not supported the prosecution regarding recovery of ganja from the accused persons and denied to have waived the same in place of seizure. That is Kapuriachak. He has at least admitted to have weighed the ganja as well as the weighed the sample each weighing 50 grams. His evidence further indicates that the airbag, MO, IBVI containing ganja were weighed by him. In that view of matter, the witness cannot be said to be totally hostile to the prosecution claim.
No, but where does it deal with his open in the police station? That part is not dealt with.
But what is the reason?
He has weighing he has done, no problem. He says that I have done it in the spot. But once he came back, it was reopened in the police station.
What is the
That part is not dealt with by the High Court. And which is again, strengthened from the evidence of the CFSL. There is no certification. Seal was intact or seal was not.
With the order dated of the London SDJ, 18.3 magnum glance.
That I have read out. 18.3.
Accused person such and such are of village such and such Ragada are produced by the escort party or Madhupatna PS being arrested and forwarded under section such and such. The acts the accused person complaining of no ill treatment. The police where the police custody peruse the forwarding letter, extract the statements, station diary entries, arrest memo, inspection memo, one sure statements, property seizure memos, Jimanama, brass of the Malkhana, consent letter of accused person, specimen signature of seal, Payu has also submitted a paper to treat the accused person as unidentified, remanded the accused such and such. So everything was produced before the London magistrate there. Brass pills others.
ତାକୁ ଖୋଲିକି ପୁଣି ରିସିଲ୍ କରାଯାଇଛି ଆଉ next letter the IO produced the seized articles with a prayer
to send the
letter means see first he has not done it, subsequently he has done it
same day. Same day it was produced.
Accordingly,
prayer to send the sample
IO
to SFL Rasul
out of the seized property, the sealed packet marked exhibit so one of the sample exhibit and required to send CFSL. Accordingly, received 3 sealed packets, one kept a packet along with the copy of functions. He produces the IO produces the samples later on the day. He doesn't produce the sample along with the accused persons. From the proceeding dated 18/3/2005. Is it mandatory that when sample was produced before the magistrate for the purpose of sending it to CFSL, the accused should be there?
Not required.
Not required.
Because it is seized in the spot and signature obtained. Unless until
Then in his their absence also it can be provided.
Because it's stationed entry, arrest memo, inspection memo, brass seal, everything was produced.
This part is need to be explained. The trial court has not dealt with PW4's that part of the evidence, which has not been highlighted with the defense also. Yes. Next point.
Next point, my lord, the IO, my lord, in his evidence on last part cross-examination, admitted that, my lord.
Para?
Last 8 page, my lord. Page number 8 of the IO's evidence.
Para, which para?
Last paragraph, my lord.
Para number
8. Para number 7, my lord.
Yes. Read
The
it.
paper slip attached to the exhibit A, D, and C.
Read full. On 17/3/2005, I sent the detailed report regarding the search seizure of so and so.
57 of
All the accused
Speak of-
persons detained simultaneously at 7:30 a.m. when they were carrying the airbag and their shoulder and so and so. Keeping the watch and after the arrival of the DSP, the search was carried out. In the above sheet, for the position personal search of each of the accused was carried out with the presence of DSP. No paper towards the personal search was prepared by me. Nothing was recovered from their person except the bag. Then the bag kept on the ground versus bag were searched when they were lying near the accused. And it is not a fact that none of the accused persons and after arriving at also the search was carried out. I carried out bed, sealing materials, paper, time frame. It's not a fact, but I have not given personal search. So the candidate in which the airbag was tied, but also see it will be done up.
Paper slip. The paper slip attached to exhibit A to D and C do not contain signature of any witness or LTA of accused. In his examination in chief, my lord, he has stated another thing.
Yes.
In paragraph 2 of his examination chief, my lord, he stated that, my lord, the paper slip contained the signature of the accused and witnesses, my lord. Whereas in the examination, in cross-examination, he denied, my lord. There was no signature or a seal of the either accused or the witnesses, my lord.
In first part he admit, later on he denied.
42 compliance, you could not make any. No. The only thing what I found is this discrepancy, it is a major discrepancy. And apart from that, nothing else. It appears that 3 gunny bags were taken, and one black color and green color and some red color airbags were there. It was put inside the gunny bag and sealed, but at the spot, it was brought to the police station. Again, it was reopened as per PW code, and that part is not explained anywhere.
Trial.
You see this.
And that part of the RFS report also, man. There was
In that light, you just see what best could be done. It's parted next Tuesday again. It's parted. Otherwise, you don't have a case. Except that part. If you can explain that part, I don't think he has a case.
No, my lord. Once the seal is breaking, it cannot be.
That is the only point he has to explain me.
Yes, ma'am.
Except that, I don't think 42 is compliant.
42 compliant. I don't.
42 compliant.
42
and 50 also.
50 also. 50 also compliant. 50 partially compliant. Partial no. Well, compliant because it's not
partial. Why partially?
Partial because of that, my lord, the independent witness. If the accused are the literate, then matter would have been different thing. The accused person are illiterate.
Show me that where they have signed that exhibit is also not there. A written note. Where is that?
313 also not. In 313 clear evidence of 3, 4, 6, 8, 9 stated such as Micho Katha. No explanation. How
but where is that slip where their endorsement was taken? That's not even exhibited.
That will be examined again.
That is not a part of record. You say that written notice I have given. They were illiterate, so therefore it was read over, and 2 witnesses have signed there. Where is that slip? And the IO doesn't say that it is exhibit so and so so and so. It is not exhibited. I have been finding. I am trying to find out that slips is not there in the record. Just see, find out.
We'll examine and answer on this point.
If that is not there, then even 42 is little dicey. Except oral evidence. Where is the documents where it was signed? Written notice was given. No problem. He says that written notice was given. They were illiterate. Therefore, it was read over to them, and 2 witnesses have signed in that. But where is that slip? It is not exhibited, unfortunately. It should have been exhibited. If it is not exhibited, whether that is a part of record or not. And in the proceeding I have seen, the proceeding which you have read out, in that proceeding, that part is also not there. Where is that slip?
We'll examine and answer on this point.
See, these are the 2 things which I could found. There is a serious discrepancy.
My lord, others matter take a look. Other matters, my lord.
How was it?
Yes, afternoon.
Lordship, item 1 of the weekly list, Lordship.
But 2 o'clock one matter is fixed. CBI matter.
That Lordship, by severe has to rush back to hospital. Someone in his family is admitted, Lordship. So, Lordship, some other day, next Tuesday, Lordship.
No, Lordship, see, I got a message that he's
Yes.
critically ill.
Let it be on the board. Then next Tuesday, let it be in the board. Okay. Then
my matter is 53, man.
53.
75.
The 53.
After lunch you come?
No, 53 some other day because after 2 o'clock I am some other.
Yes.
53 some other.
Then 73. 75 you are. Okay.
Item 10 is also a small matter that.
We'll see 75 and 10 both.
The pen drive we will take out the entire.
You can take it. No problem. Yes.
Yes. 75.
25.
Last data.
Yeah, that would
Three appellants are there, Your Lordship.
The affiliates?
Are there. And they all are convicted under section 294, 506 and 34 of IPC for simple imprisonment 3 months. And Your Lordship, under section 3(1) Acts of the SC/ST Act for 6 months simple imprisonment 1,000 fine, Your Lordship. My Lord, I have prepared a note minutes. Sir.
Yes. Yes.
Before going to the fact, Your Lordship, one most important thing is that they have long-standing disputes. Their prior enmities there regarding on a land, Your Lordship. This is an unsurveyed basti land, my lords. They were used as garbage area, Your Lordship, and they have filed. Both the parties have filed the criminal cases 144, 145 against each other, and one civil case was filed by the complainant before the HDGM Jaipur, Your Lordship. That is there, that is prejudice. And my lord, in this case, Your Lordship, that is on 15/2008, my lord, June 15, 2008, approximately 10 a.m. at village Zamunda, Your Lordship, appellants allegedly
Humiliated monarch prison
yes.
in front of his house using caste-based obscene language.
Yes, my lord. And everything, this criminal case is started from that.
Yes.
Yes. My lord, the allegations are like they have using the slurs, which is caste-based slurs, and other the intimidation is there. This is the allegation, Your Lordship. Most important thing is that, my lord, there are 5 prosecution witnesses are there, and all are Your Lordship interested witness. How, Your Lordship? The appellant PW1 is the complainant, PW2 is the relative of the complainant, PW3 is the advocate who has drafted the petition, Your Lordship. 4 is the father.
The complaint.
Yes, my lord.
Yes.
And 4 is the father, and 5th is the wife of the PW2, Your Lordship.
Yes.
And all are the interested witness. No, and for that reason, Your Lordship, section 3(1) Acts, which is replaced by R, Your Lordship, in 2016, is the public view is not made out.
You have written.
Yes, my lord. I have cited one. Hitesh.
You have written charges were officially framed. What is officially framed? Charges are framed of evidence official. Anyway, yes.
So
trial commenced with examination. Okay. Given a very minute detail, everything, huh? Different witness. When they were arrested?
Arrested, Your Lordship, on the date of 39 days of undergone period, my lord.
30?
39.
39 days, huh?
Yes, Your Lordship, during the period of trial, they all are on bail, Your Lordship.
Okay.
On date of 18/11/2010, the judgment date, Your Lordship, they got arrested, and 27/12/2010.
27/10.
2010. They got the bail from High Court, Your Lordship. Orissa.
27?
12, Your Lordship, 2010.
No, 12. No?
Yes.
7, 12.
2000.
So it is about 12 days.
Bail, I think, Hon'Ble.
Okay, then 27, huh?
Yes,
It
sir.
is 27 days plus, okay, 29.
12th month and 2010.
Okay. Yes.
So, my lord, in this case, Your Lordship, as in, my lord, the prosecution witnesses are interested witness. They have filed the civil matter. The PWT is the plaintiff of this civil case, Your Lordship. What is filed? And all other, the Manohar Harijan, who is the complainant of this matter, he is also there in the plaintiff category, Your Lordship, against these appellants, Your Lordship.
Okay.
So they have long stand. They want the
Earlier there was some dispute, 144 dispute, suit and everything is fine. Let us see in that context, if you see PW1, let us see PW1. PW1. Good.
PW1 is derived from the allegation, Your Lordship.
Yes. Yes. PW1 I read.
PW1.
I read already. Yes.
My Lord, PW1 is.
Who is IO? IO.
IU.
There is no IO here, obviously, because complaint case.
Yes.
And what is the evidence brought on record to prove the caste of these accused persons?
They have filed one certificate.
Who has filed? See, he has proved his caste certificate.
Yes, Your Honor.
But what about the accused?
Accused. They are general caste.
How do you know?
They didn't have file any caste certificate, Your Lordship, to this, but they just.
That was the obligation on the part of the complainant to prove. The accused person belongs to general class.
Yes.
It is not only to you have to prove that you belong to HC or ST. It is an obligation on the part of the complainant to prove otherwise also.
Exactly.
This is one requirement.
Yes, Your.
This is one apparently leaking.
Yes.
Okay. Except in the oral testimony at the top of the first paragraph saying that I am a Dumbo caste, came under scheduled caste. Accused person, bracket the witnesses produce their names, are not horizons. Therefore, they are not coming under the scheduled caste and they are Telugu people only. SC and ST? SC, ST, na? SC, ST, you know. Merely because they are not Harijan doesn't mean that they are not belongs to scheduled caste. So therefore, this evidence is neither here nor there. Yes.
My Lord, my submission is that the allegations are vague and false because your lordship the interested witness.
Yes.
Lord, section 3(1)(r) is saying that your lordship.
Yes. Yes. Go ahead.
Intentionally insults or intimidates with intent to humiliate member of a scheduled caste or a scheduled tribe in any place within public view, your lordship.
Yes.
So public view is not that, your lordship, not within four walls, my lord. That may be visible to the public, your lordship. But my submission is that whether public is other than the relatives or family members are there or not, that is also comes under public view. My lord, I have one judgment that is I have already cited. My lord, the Honorable Supreme Court is also saying that public view may not be in the attract the four walls, my lord. But the public view other than the family members and relatives should be there. It is for
Yes. Which paragraph?
14, your lordship. Paragraph 14 of that.
Para 14?
Yes, my lord. Oh.
Yes. Yes.
May I read, your lordship? Another key ingredients of the provision is insult or intimidation in any place within the public view. What is to be regarded as a public place in public view had come up for consideration before the High Court. This court in the judgment report of Swarna Singh and others versus State Road Standing Council and others. The court had drawn distinction between the expression public place and in a public place within the public view. It was held that if an offense is committed outside the building, that is, for example, it is in lawn outside a house and lawn can be seen by someone from the road of lane outside the boundary wall, then the lawn will certainly be a place within the public view. On the contrary, if the remark is made inside building, but some members of the public are there, not merely relatives or friends, then it would not be an offense. Since it is not the public view, the court held as under, your lordship. This is the thing. And paragraph 18 also, your lordship.
So what in this case, where this has happened?
It has happened in
neighbor how relation?
It is in the public view.
No, your lordship, it is not in the public. It is, this matter has happened in four walls. The thing is that, your lordship, kindly see the paragraph 18, my lord.
18.
My lord.
18. The judgment.
One second.
18 of the judgment you are talking?
Judgment.
Yes. It's all right.
Therefore, the offense under the act is not established merely on the fact that the informant is a member of ST scheduled caste, unless there is an intention to humiliate a member of scheduled caste or scheduled tribe for the reason that a victim belongs to such caste. In the present case, the parties are litigating over the possession of the land. The allegation of hurling of abuse is against the person who claims title over the property. If such person happens to be scheduled caste, the offense under section 3(1)(r) of the act is not made out.
Yeah. So it is nothing to do with public place and public view. This judgment into this extent, para 18 you can very well utilize in the sense that there was a dispute.
Yes.
Repeat 144 proceeding and everything was drawn up. So therefore, if relating to that dispute, if the accused have scolded him, that can't come under the purview of the HCSC Act because he was not scolded to be humiliated, but for the property dispute he is scolded. So therefore, it will not come under the
Meaning, it's.
the provisions of the HCSC. Yes.
And my lord, 506.
But have you checked? Because see, I'll tell you what is important here is see this is an offense. It has taken place in 2008. By that time, the rule had already come, Rule 7 and all. It says that every such complaint has to be investigated by the officer not less than the rank of DSP. This is the situation where an FIR is registered. Here is a case, there is no FIR registered. Straight away, a complaint case is filed. What are the parameters required for these kind of complaints? It is simply like 200 complaint or something else has to be done.
Right.
That needs to be looked into.
So that part I will.
That part you
Then-
see. Because see, these are the statute, special statute, and the stringent procedure has to be followed. Procedural safeguards are given. But once you are not filing a complaint, straight away you are filing a complaint, direct complaint. If a FIR is filed and a closure report is filed, protest petition filed, it is something different. But it is a straight away complaint is filed, drafted by a lawyer. And lawyer is also examined.
Yes.
Lawyer is also, what is the parameters? Let us see the complaint. In the complaint, what he says. Does he says that has he filed a complaint before the police and police did not take any action? Let us see.
Yes, your lordship, that is there. The
Where is the complaint? The complaint, which is that exhibit? There is a final form also is there.
That is a little bit different.
The FIR was registered.
Yes, that is a little bit different case.
Huh?
They had an enmity with each other since long.
No, no. Exhibit, see exhibit B, just see.
Yeah.
Exhibit B. What is this exhibit B?
Prestige in the report, so report, if you are number 58.
The previous This is a previous FIR.
Okay.
That has been stated by PW.
Okay, next exhibit C, therefore,
Yeah.
complaint.
Exhibit 2 is the complaint.
Exhibit 2 is the suit. Suit is also
Yes.
exhibit. Yes. Exhibit?
Exhibit 2 is the complaint.
Where is exhibit 2? Where is exhibit 2, bhai?
You're also in judgment.
1 minute, let us see the
Yes,
exhibit
yes.
2 first. Where is that? There, these are evidences. Where is the exhibit?
exhibit is not.
Where is the complaint?
It is at page 24 of the TCR.
24 paper.
7
Yes. Yes, let us see.
Judgment. Hence, the reported matter is writing for the appeal station, and the next day, on which no action is taken, no is there for the complaint case of this.
At page 26, it has been written whether any information was given to the police. Yeah, he has written yes. On 16/6/2008, a written report was submitted by the
Where?
government. So page 26.
26.
Top
In
of
this
the-
regard, a complaint presented in written report to YC.
Vice
So and so and so.
Till now, the vice
But after receiving the same,
that
it did
the
not
copy of the file-
grant free
Take-
copy to
Yeah.
till today. The IC
It is also not taken any legal action on the report of the complainant. The complainant was under the expectation of investigation. The pollution. Rules of
This was also reflected in judgment para 2.
When the complaint was filed?
That complaint was on 25/6/2008. He lost the complaint case in the court of excision, Jaipur. It was registered as 171 of 2008.
But if you read the complaint is something different. And in the evidence, it is something different. See the allegation in the complaint. Where is the specific allegation on what? Previous occasion, the accused persons abused the complaint in the Hindi language, saying
Lastly, the accused person
the complaint and the annoyed to such a word
the atmosphere and cause injuries.
of the accused persons.
The previous occasion, the
Para 2 and 3 stated the exact version in which para PW 1 and 4 are stated. You should kindly see para 2 and 3 of the complaint.
Yes, 2 and 3 I read it.
Yes. In para 2, they say the background, and para 3.
And para 3 is the incident.
Yes.
Para 3 is the incident where in Oriya it is written.
Yes. The exact language which has been employed in the by PW 1 and 4. And the written report is also relied upon by the complainant in the
Yes, that is the Xerox copy of the
document relied upon the Xerox copy of the written report and so on. They should have waited for some more time maybe.
How do you know that they are general caste? What is it?
Lordship, your Lordship is correct. When it is a prosecution case, when it is a state initiated case, it is the duty of the prosecution to bring in a record both the caste of both the parties. Since it is a complaint case, and
It will be done away with.
it is the case, the applicant should have stated that I belong to a general caste. In the 313 statement, they have not taken any stand that they belong to a.
Let's see 313.
Yes,
That's the whole difficulty. These people, while conducting.
So they have not stated anything in their statement that they belong to the same caste.
Has it been put to them?
And no particular question has been put to them.
Unless it was put, how will they volunteer? In 313, can they volunteer?
So in 31, yes, they can.
Unless you say you belongs to general caste,
Yes.
unless that question is there, where is the question of answering?
First of all, 313 statement is regarding putting the
Complaint and the garbage from
the accused.
transfer that evidence of period advocate who draft the complaint petition prepared complaint petition to instruction of
one type of policy insulted by military caste, but you say I'm insulted. See the point in that caste. Like the general को direct पहुंचा के दिखे दिखेगा. Then company. That's what the complaint. That was a seen acceptable.
Kindly see question number 6. You have
Question
heard
6.
the question number 6 of the statement.
Okay.
You have heard the evidence. What more do you want to say? Jaga pai ama bhitere case
No, that is regarding the but caste.
They could have said it to.
They could have said so many things.
They could have said it.
But unless this question is, it is regarding the incident it was asked. And he says that there was a dispute for the land. So therefore this has happened. That's not. Let us see DW1, what DW1 says.
Yes.
What is the evidence you laid?
Even DW1 said I belong to general class, this was also general class.
Page 56 है देखो
Yes, DW I'm reading.
Yes.
At page 2 of his evidence. In fact, he kind of confirms the previous anonymity. Now the accused persons have stopped dumping wasting materials. Now they are trying kettles and stuffing straw. After the police case,
Why have you laid the defense evidence? I don't know. See the question which you are asking, and they are asking their evidence. I was thinking that on that ground I will give you benefit. You cut your hand. Your own witness comes and says that I belong to general caste, and these people are also belongs to general caste. And coupled with that fact, the witnesses and everybody says that we belong to horizontal class. They don't belong to horizontal class, therefore they are general caste. And that now got corroboration from this. That's the whole difficulty. If you don't carefully do it.
It is not good. Just boring thing. You say thing. Yeah, I don't know. So he could have been better. He looked at it. But
then further, just see, it is also suggestion. It is not a fact that I being the member of general caste, I am depositing in favor of the accused persons, and the accused persons have scolded so and so, so and so. Then you have 2 points which what you are trying to convey. One is, it is not a, there is a difference between public place and public view. In public view, it should have happened. The incident has not taken place within the public view. This is one point. Second point, what you are saying is due to the enmity which has been apparent on record, due to the past enmity, and these people have some argument, whatever. And in that process, they might have used this language, which is not intended to humiliate them, rather it is but for the property dispute.
Yes,
so therefore, SC will not come in.
Yes, sir.
These are the two basic points you are trying to convey.
Yes.
And what are the other offences?
294, 506, and 34. 3 months.
506, then 34. If 3 SC it will go, then for other offences.
Milord, that is also in
ଗୋଟେ ଜିନିଷ ବି ଅଛି ତାଙ୍କ ଫେଭର ଗୋଟେ ଯିବା କଥା ଏମାନେ ଯୋଉ ସମସ୍ତେ କହିଛନ୍ତି ବି ସମସ୍ତଙ୍କର ମାନେ ୱାର୍ଡିଂ ଟା ସମସ୍ତ
Variation. I have seen that. I have seen that. Complaint ରେ ଗୋଟେ ଅଛି ଆଉ ଗୋଟେ ସମସ୍ତେ ଟିକେ ଟିକେ change କରିଛନ୍ତି.
କିନ୍ତୁ ଅବଜରଭେସନ ହଉଛି ଆମର ହାଇ କୋର୍ଟ ଦ୍ୱାରା ଯେ ଭେରିଏସନ ଅଛି କିନ୍ତୁ ସେଇ ଯୋଉ କାଷ୍ଟ ଯୋଉ ୱାର୍ଡ ସେଇଟା ସମସ୍ତର ସେଇ ଏମିତି ହୋଲ୍ଡ କରୁଛନ୍ତି.
So that benefit ଦେଇକି ଯଦି 1x ବାହାରି ପଡିବ, then we can give provision. I'm trying to add that only.
PW2 achi neighbor independent witness.
Not independent, it's a relative. He admitted in that part.
Relation doesn't mean ki family may
Can't discard the evidence merely because they are relative.
He is the person.
What does he say? What does he say?
Civil matter.
who says
Civil case.
I know the
And it appears there is a fight because of something.
It's a long-standing enmity.
The enmity, so therefore,
144.
because they belong to Horizon, they thought it's better that to improvise the case and put them in 3
They kept-
that has happened.
That they kept on dumping the waste for which there is a civil suit, there is a 144 proceeding, there is a previous FIR.
Therefore, the para 18 which he has shown,
Yes.
the judgment, he is directly covered by the para 18.
The PW2 says I am the neighbor.
But he is the plaintiff of the civil case, Your Lordship.
How does
He is
it make a
the
difference?
First, plaintiff number 1 in civil.
That's your reason.
Yes, Your Lordship.
Ghasi Harijan.
Yes, my lord. And
Maybe, but that doesn't mean that there is no. There is a civil case
Me
about.
becoming a plaintiff has no bearing in the criminal case.
ଆଉ ଗାଁରେ ସବୁଆଡେ ସମସ୍ତଙ୍କର ଏକା ବାଡି ପଟେକି ପଶି ଯାଇଥିବ କାହାର ଟିକେ ବାଡି ଗୋଟେ ଗଣି ଦେଇଥିବ ତାଙ୍କର ସମସ୍ତ ଆଉ ସମସ୍ତେ ତାଙ୍କର ରିଲେସନ ସବୁ ତ କକା ଖୁଡି ସମସ୍ତଙ୍କୁ ଡାକନ୍ତି।
that cannot be comes under the independent witness.
He says my house is also near the house of the complainant.
But he is also admitted on the
I'm reading.
Yes, okay.
My house is also near the house of the complainant. I was standing outside of my house. Therefore, I could hear. I also belong to Domo caste. I felt very much insulted. But regarding our caste, he took it upon himself.
And there's a cross ରେ ବି ଗୋଟେ ଲାଇନ୍ ଶୁଣ the complainant is my relation ତା ପରେ he is only a caste man ସେ ଇଏ ବି କଲା ଯେ ରିଲେସନ
ଜାତି ଭାଇ
ଜାତି ଭାଇ ସେଇ ହିସାବରେ ରିଲେସନ or else
that way he is independent.
That way he is actually. Otherwise, PW4 since he is the father, he is not
And
independent.
PW5 is the wife of.
I tell you, these SC/ST provisions are being used like this only. Maximum used like this, but and these people are being scolded for that only. They belong to lower caste, and
They
whenever
are exploited when they come up with as a weapon.
Yeah. Both the things are true in true sense.
So two ways what is properly serving.
ସେମିତି ଇଏ ହଉଛି ମୋ ଭାଉଜ ସରିତା ଆମ ଗାଁରେ ଆଉ ସେଟା ହେଇଥାନ୍ତା PW ରେ କିଛି ନ କହିଥାନ୍ତା ସିଏ ତା ଭିତରେ
problem. Examine କରିବା
ବେଶୀ ଭଲ ଲୋକ ବାହାରିବୁ the incident is in front of the house. That means that is the public road. In front of घर भीतर था बारंदार था कौन था सेटा हम कहते हैं it's between the four walls.
Yes.
But when the incident is occurred in front of the house, that we cannot say that just come down the house, the four wall of the house. Yeah. Thanks.
Can there be a conviction under section 294 as well as section 3(1)(x)?
Yes.
Yes.
Yes. That can be.
Act is same.
Yes.
Act is same but two offense.
Actually, two offenses.
Two. Why?
Since, for example, POCSO and 376, they're not mutually exclusive. Same as SC/ST Act as well as 290. They're not exclusive.
Because the expressions are same.
Yes, sir.
Yes, madam. Anything else?
294 is also, Your Lordship, mere expression of during a limited argument.
It is public annoyance.
Public announcement, my lord, public is not there.
Suppose, for example, a situation will be you scold him. He may not be affected by that. And the other people, those who are there, they got affected. He may not complain. The other people can say. And 294. That is 294.
That is on the
Public annoyance. Anything which is in public annoyance. A person to whom you have addressed might not have become affected, but the public at large. So therefore, there is a difference between public place and public view. And 294 is public place, and 3x is public view. That's the distinction.
Yes, Your Lordship. My humble submission is that only on the heated argument that may be an expression and create such annoyance in that part. Otherwise,
How can you improve your case then? That's the only thing I think 3x we can somehow try to find out some way. Hmm? 39 days you have already undergone. So what we can do is, insofar as 3x is concerned,
The problem is
record an acquittal.
that is a minimum sentence of 6 months.
So therefore, that has to go for to give PO. 39 days they have already undergone. So by acquitting them under 3x on some other ground, manufactured ground,
Maybe some
and then give provision. That's the only way you can save it.
some compensation or may fine may be imposed to that effect. So that
Section 5 is there, PO Section 5 compensation.
That can be-
That we can do. Para 18 is important. This para 18 can come under your Act. Para 18. Evidence. Evidence enough. कितना है लाजी? I think 4 appeal is enough. Give dictation.
37 weekly.
Getting accumulated. Slowly, even if I'm avoiding, accumulating so many judgments. Somehow, but see, I am worried about one thing, that see, 90s matter are still there. These are 2010 and all. These people are somehow there.
Only 1 or 2 matters are there.
9600.
Guys, sorry.
Key.
Sumit Lal is there in 376, SCST Act is there. And I will inform him, then my lordship.
There are some matters where MLK security is appointed. Appoint these people.
Sorry.
Do you have any other matter with you? Which we appoint? Appoint him.
Weekly 37.
Yes.
Weekly 37.
37.
Headmaster is not
Tomorrow. Sorry? No, give here also. Give your name. Name is there. Give him the name and see, these people are there. You ask them who can be appointed as amicus curiae. Please assist. But see the experience also, depending upon the seriousity and you just check the offense and suggest. And it should be equally kind of distribution. It's not concentrated to people.
97 ଖାଲି ଗୋଟେ ରହିଲା ସେଟା ଟ୍ୟୁଜଡେ ଦିନ କହିଲେ ସେ ମିଷ୍ଟର ଲାଲ ଥିଲା ସିଏ ତ କହିଛନ୍ତି
97 କାଲି କରିଦେବ ନା
କାଲି
ମଙ୍ଗଳବାର ଠିକ ଅଛି
ଆଉ 7 ଆଇଟମ ତ ସରିଗଲା ଆଜି 2000 ସରିଗଲା
wherever the amicus curiae to be appointed, just check it out and take their acceptance and what some young generation people, those are not getting.
Swagatika
ଦିଆ ହେଇଥିଲା ନା ତ
Give the name. I don't know anyone. Give the name. We'll appoint. No problem.